So, Council, we are all present. We are reconvening. So we're going to have one more round for questions. And should there not be any more clarifying questions, they should have all been answered given the amount of time that we had. But if there are any further clarifying questions, ask now. I'm closing the public hearing otherwise, and then we'll begin our deliberations, perhaps with a motion. So, is there, Vice Mayor, you have a clarifying question, and I have another hand raised from Councilmember Fruin. All right.
Yeah, okay. First of all, it's the earthquake fault zone issue that I think on one map, it shows the village court is outside the fault zone, but on another map, it seems to be within 300 feet of Monta Vista fault line. So do we have any explanation about those maps? And here, yeah.
Yes, our firm did quick analysis on that based upon the map that was included in public comments that came in. And it turns out that the official geological organization of the state produces more than one map. They map all various different fault lines and different maps for different purposes. And the specific map that is called for in the statute is the map that shows active fault lines. And we produced a memo, a confidential memo to council that shows that the active fault lines in the area are not beneath the village property. They're quite a ways away.
But the government code section says any formal map that's from the state.
Let me just take a look at this. Yeah, let's see. Such delimited earthquake fault zones are what are contemplated in the language of AB 130.
I think any official maps, that's the language.
To determine the location of these delineated earthquake fault zones, the state geological geologist publishes a map with Alquist Prolio, however you pronounce that, fault zones depicted on them and available for public review. So I think they're just supposed to be showing the Alquist Prolio fault zones. And the item showing those fault zones indicates that there isn't a fault zone underneath the property.
Yeah.
And then based upon a review of the aforementioned fault zones, the state geologist has not delineated the Monte Vista Fault as an earthquake fault line that meets the standards in Public Resources Code, Section 2622, Subdivision A, as, quote, sufficiently active and well-defined. Title 14 of the California Code of Regulations, Section 3601, explains that a fault is active when the fault has had surface displacement within Holocene time, about the last 11,000 years, hence constituting a potential hazard to structures that might be located across it. The other maps include fault lines that have not been active for approximately 700,000 years. And so those fault lines are not of concern in terms of being underneath the land.
Okay, so I'm sharing my screen where here, highlighted here is the language that's in the AB 130. It says, within a delineated earthquake fault zone as determined by the state geologist in any official maps. published by the state geologist.
This memo references Public Resources Code, Section 2622, Subdivision A. Let's take a look at that.
So are you saying the state, I don't understand what exactly is delineated the fault zone, but where does it say that only the active ones? You are saying Monta Vista fault is not active?
The Public Resources Code reads, in order to assist cities and counties in their planning, zoning, and building regulation functions, the state geologist shall delineate appropriately wide earthquake fault zones to encompass all potentially and recently active traces of the San Andreas, Calaveras, Hayward, and San Jacinto faults, and such other faults or segments thereof as the state geologist determines to be sufficiently active and well-defined as to constitute a potential hazard to structures from surface faulting or fault creep. The earthquake fault zone shall ordinarily be 1/4 mile or less in width, except in circumstances which may require the state geologist to designate a wider zone. So our analysis suggests that this section of the Public Resources Code is referencing fault zones that encompass active traces of those faults that I described.
Okay, that's fine. The next question is regarding the, so I'm, how do I share? Stop share. Okay,
Pardon me, could I add something to that as well?
okay.
Is that
The,
Oh, yes, Pam,
Pam,
please, thank you.
My apologies. Thank you, Vice Mayor and members of the City Council. I'd like to add that AB 130, with respect to compliance under Section Government Code 65913.4, the part that you quoted, requiring that it be determined, the earthquake fault zone being determined by any state geologist in any official map published by the state geologist. The caveat to that is it's not allowed to be within an earthquake fault zone as listed on any official map. That is correct. However, the caveat to that is unless the development complies with applicable seismic protection building code standards adopted by the California Building Code Standards Commission. And I believe that based on the review of the compliance and how the building structures and facilities at the proposed development are constructed or will be constructed, I believe they should comply with all the applicable building codes under state law with respect to earthquake readiness and seismic readiness. And so I think that is what would exempt this project under AB 130 with respect to earthquake fault zones.
okay. Thank you. So next, this is a slide from the applicant regarding the specific section from AB 130 that about the very high fire severity zone. So it's supposed to within a very high fire severity zone, they should not get the AB 130 exemption, except here is a carve out. This paragraph does not apply to sites that have adopted fire hazard mitigation measures pursuant to existing standards and so on, and then 3 items listed. I've been trying to comprehend this. I asked about what are these adopted fire hazard mitigation measures, and the city staff pointed me to the November 4th city council meeting when we adopted the building code. So I went to look at the staff report and then the resolution that we have adopted, nowhere does it mention that the adopted mitigation measure would exempt a very high fire severity zone from CEQA at all. Then the staff report states that the intent is to have consistency in the application of codes related to fire safety. The amendments have been provided to all cities within Santa Clara County Fire Department jurisdiction, as well as surrounding county jurisdiction, to be included in their respective code adoption for consistency of enforcement. Plans submitted after January 1st will be required to comply with the new California 2025 California codes, along with local adopted amendments. So my understanding at that time was we are just adopting some major, some local code to comply with the state code. And I had no idea, and nowhere does it mention these are adopted measures for any sites or for the entire city, so that they could become adopted mitigation measures to qualify for AB 130 exemption. So I don't think the adopted building code from the November 3rd meeting meet the requirement for the AB 130 for the carve out created by AB 130. And plus, the planning commission, I think multiple planning commissioners attended the Planning Commission Academy, where the same consultant who provided an opinion on the AB 130 exemption for this project, the same consultant firm, I don't know if it's the same attorney, told more than 100 planning commissioners during the meeting that very high fire severity zone developments should not be exempt from CEQA via AB 130. So apparently, it's not the intent of AB 130 to allow cities to allow sites, to allow cities to just adopt mitigation measure to be consistent with the state code and then call it mitigation measure for very high fire severity zones. Can you help me understand? Where have we adopted anything that would mitigate the impact of very high fire severity zone? I looked at the adopted resolution from November 4th. Nowhere does the resolution mention very high fire severity.
I understand that the resolution doesn't mention very high, but the resolution does adopt the building code 7A, and the city was required by the state to adopt those
I know
codes.
those are minimum standards. That doesn't mean they are sufficient. They are just minimum standard.
My interpretation of the statute is it says that it means to exempt very high fire hazard severity zones from the AB 130 exemption, but then it encompasses, most of that world and pulls it back in. And why the legislature passed legislation like that, I can't say.
And
I would
also
agree
they
it's not necessarily eloquent, but I do think that that's what it means.
And what's significant here is it says this subparagraph does not apply to sites that have adopted mitigation measures, not just, a city have adopted some mitigation measure.
I agree
We
that-
adopted some fire code according to the state, but we have never adopted fire hazard mitigation measures for any specific site in Cupertino, especially any specific site in very high fire severity zone.
I think there again, the legislature was not really very eloquent in terms of their drafting. I'm not actually sure
I'm
how.
trying to comply with the law.
I understand.
We are all trying to comply with the law. The law as written. The law as written is this subparagraph does not apply to sites that have adopted fire hazard mitigation measures.
I would
As
interpret.
written,
I would
and
interpret that differently.
we don't have adopted mitigation measures for any site in Cupertino to exempt it from AB 130.
I think it's the other way around, that we have adopted
I think
it to apply to all sites.
it's your interpretation.
Well, and I think it's a reasonable interpretation. I think
I
it's
think my
likely what
interpretation
the
is more
legislature
reasonable.
intended. And
It's what the legislature intended, because David J. Powers also mentioned that at the Planning Commission Academy. AB 130 is not meant to just be a blanket exemption for very high fire severity zone.
I think the person, Mr. Powers, is.
I'm not asking for your opinion, actually. Now I'm just stating my opinion.
Thank you.
There is no need to. So this is my interpretation of, I think we are all trying to comply with the law. And HCD letter, the whole purpose of that letter is restating all the state law, and then stating that in the HCD letter, for purposes of entitling AB 130 eligible projects. It's not saying the project is AB 130 eligible or not. It's simply saying, if it's eligible, the city should assume compliance with local building codes. That's it. HCD is not telling the city, you have to find AB 130 exemption. But HCD is telling us we must follow the law. And this is all I'm doing, trying to follow the law as adopted by the legislators. Thank you.
Thank you, and please try to stick to clarifying questions. Councilmember Fruin, you have some clarifying questions?
Yeah, first, it looks like Attorney Lee has her hand up, so I would like to give her an opportunity to speak again if she had something further to offer.
Thank you.
Sure. Thank you very much, Councilmember Fruin, and members of the council. I would like to add that, with respect to the carve out for sites that are located within very high fire hazard severity zones, the law as written does state that a site that does have fire hazard mitigation measures in its proposed development, and then it lists out the 3 types of applicable state mitigation measures that can be followed. I would like to clarify that, first of all, there had been questions with respect to the applicability of 4291 under the Public Resources Code, and that specifically speaks to areas that are within the state responsibility area. That does not apply to cities which are under the jurisdiction of the local responsibility area, either the city or the county. Section 4291, and I think the fire chief had alluded to it, does specifically apply to those rural areas that are under the control of CAL FIRE financially, and with the objective standards of taking care of those areas that are unincorporated and within state lands. And so it's not determined to be directly applicable in this case. For those under Public Resources Code, Section 4290, that is applicable for local responsibility areas. And so that does apply. And I believe that there are certain aspects under the fire safe regulations that make it applicable, as, again, the fire chief and the assistant fire chief had spoken to in detail earlier this evening. And lastly, with respect to Chapter 7A of the California Building Code, that has been adopted in essence by the city back in November. And with respect to those requirements of the building code, the applicant has met them or will be required to meet them. And this leads to the next part. When the HCD letter says that it assumes, or the city should assume, that it meets the requirements under AB 130, they're partially correct in the sense that, yes, they do meet it, under these standards, but as part of the fire safe regulations and as part of the fire code, there are post-entitlement requirements that the applicant would need to meet. Those are not necessarily at the review level of the pre-entitlement process, which is what we're discussing tonight. And I'm going to turn your attention to the fire prevention plan review comments that were submitted by the fire department, I believe in January of 2026. The review comments, this was the plan status. The fire department did approve it with conditions. Condition number 2 was to provide a final fire protection plan at the time the building permit submittal occurs. And so that's what we're referring to with respect to post-entitlement requirements to meet the fire code. They're not ready because the plans are not at the detailed level that are required at this time, but they will be required in the future post-entitlement pre-permit issuance. And that's when the completion of meeting the fire code should occur. And that would entail a full review of all the fire code requirements, building code requirements as it pertains to fire prevention and fire suppression and evacuations. And at that time, it will be determined whether or not to meet the requirements under AB 130.
Mayor, just want to respond. So what I'm sharing the screen again because Pam is talking about this particular section. Section 4291 does apply to SRA only. However, for local LRA, Section 51182 still applies. So, but that is not mentioned. I think that's what a lot of the member of the public is wondering, how come this is not specifically mentioned. I understand that eventually they will comply with this section. And so Section 4290 is contains the 30-foot setback requirement. And Chapter 7A, thank you for clarifying that November 4th adoption is mainly for Chapter 7A, which means we really don't have, the applicant has proposed mitigation measures, proposed, not adopted. Proposed, if the legislature meant this project to get AB 130 exception, as long as someone proposed a list, they would have said so. But they said does not apply to sites that have adopted fire mitigation measures. And that fire mitigation measure should include the following 3, but not limited to, which means it's a responsibility of the local lead agency, which is the city, to adopt mitigation measures to ensure we address the impact in very high fire severity zone. I don't think we have met that standard.
Ms. Lee, is that your read of the law?
I'm reading the law. Yes.
I understand that. I'm interested in her opinion. She's an attorney.
Thank you. Through the chair.
With my understanding of the way the law was written under AB 130, I already explained what I believe the law to be as it was adopted by the state legislature.
Okay, I appreciate that. I'll turn to a few other questions and clarification that I had for you, so I'll start with you before going to staff on others. There's one point that has me somewhat confused, and I think that some of the comments from the public are directed toward it. We're right now technically at a discretionary hearing. Granted, that discretion is severely hemmed in by the HAA and other law. But there were a number of claims that somehow AB 130 is only applicable to ministerial processes. That doesn't make any sense to me. It's an exemption to CEQA, and by its own terms, CEQA would not apply to a ministerial project to begin with. Is that accurate?
Yes, that is. Public Resources Code, Section 21080.66. Refers to projects that are statutorily exempt, and this qualifies based on the checklist listed out under that section of the Public Resources Code. There was an earlier reference to potential cumulative effects that would draw it out under CEQA and require a full environmental review. I will restate that that is only applicable for categorical exemptions from Class 1 to Class 32 under CEQA guidelines, but this is a statutory exemption that the legislature has specifically carved out for housing development projects.
Thank you. That's also very important context. You actually got to my next question ahead of me. Turning back to the Housing Accountability Act and the various penalties that the city would be on the hook for, we did hear from Applicant's counsel. Would you broadly concur with the nature and scope of the penalties that could be imposed on the city if it wrongfully denies the project?
Yes, I believe with the recent enactment of, I believe it's AB 712, it provides a clear roadmap for how penalties and enforcement actions would occur for jurisdictions that violate housing reform laws and housing element laws under 66589.5 and under housing element law in general, which would include the Housing Accountability Act and the Housing Crisis Act under SB 330. It does state that to the extent a matter is litigated for alleged violations, if the prevailing party is the applicant, immediately when that occurs, the city would be on the hook for not only its own attorney's fees and costs, but the applicant's attorney's fees and costs, as well as the requirement to pay for a penalty, in essence, at the rate of $10,000 per unit. And so whether or not this is an additional violation of the same law where the 5 times factor would be involved, that remains to be seen. But assuming that that's not the case and this is the initial violation, that would be the amount we could be, if there is litigation and assuming the applicant prevails in a matter for this, there could be an upward of $1 million or more in fees and penalties. I will add also that HCD could look into decertifying the city's housing element, which would then open the door for builder remedy projects, not just here, but anywhere within the city. And that is a more serious violation and more serious concern that I think the city would be facing.
Okay. So just to build on that a little bit, you mentioned Government Code Section 65589.5. That's the Housing Accountability Act. Under the Act, it specifically reincorporates the violation of a whole bunch of other laws as de jure violations of the Housing Accountability Act themselves. Most of that is codified at Subdivision H. It includes things like the Permit Streamlining Act, and the wrongful denial of a CEQA exemption, like AB 130. Is that your read?
Yes, that is my interpretation of what the law states under 65589.
Okay. And I would just note, and you know, if you would like to opine, you are welcome to. The city is currently involved in 2 matters of litigation involving 2 builders remedy projects. Both of those are brought under the HAA, and both of them impact the Permit Streamlining Act. We have notices of violation from HCD on those topics, and both of those cases are nearing a point where we would have orders resolving the matter. So wouldn't those just count as strikes?
Under AB 712, it specifically states the same violation for a specific law. Whether or not it could be couched under 65589.5 or some other law, I think that is certainly subject to interpretation, but I think the position that HCD would take would be yes, that is a violation under the Housing Accountability Act.
Okay. Well, I mean, just by itself, if they all 3 of them are violations of the HAA by themselves, then wouldn't that be a normal consequence? That feels like it logically flows.
It depends on how it's interpreted, but I certainly think with the way HCD has been opining and providing its take on what the law is, the government code, that would be their position.
Okay. Thank you. I will turn for the moment back to staff. At the prior density of this site, before the enactment of the housing element, the permissible density was something on the order of about 14 units on this complex of parcels, correct?
Something like that, yeah.
Yeah, it's like 7,500 square feet at R1, and it's 2.5 acres.
2.5 acres.
Yeah. So that's actually over 14 units.
Yeah.
Okay. Under the rest of our zoning code, and frankly under state law, you could permissibly also build up to 3 ADUs on each one of those sites, yes?
That is correct, yes.
Okay. Just for the record, 14 by 4 is 56, which is more than this project. So I'm just curious to hear maybe from Fire how we would treat those ADUs under an alternative scenario, because it seems like even if you reverted this back to the original zoning, it doesn't really change the equation. I don't know if the chief's available.
On his way.
Sorry to spring a hypothetical on you at the last minute.
No problem. I'm going to ask you to repeat it, please.
Under the prior zoning, you could have had 14 and a half, that might round up to 15 units on this collection of parcels, the same site that we're talking about today. And under state law and under our local code, you could have up to 3 ADUs on all those sites as well. That's 56 units at a minimum if you calculate it from 14 units. So how would Fire treat that situation compared to the one that we're facing here, especially given that ADUs can ordinarily be built as close as 4 feet to an adjacent property?
Yeah, that's a great question. The thing is that the density on a regular parcel could actually be 3. You can have the house and then the ADU, JADU. So that does create essentially that same type of density. It is one of those things where it's very dependent on who's building and what they decide to build. The setbacks are super important. The distance in between 2 buildings are very important. So there's a separation component. The numbers are fairly similar. So you would have a scenario that is extremely hard to predict what it is, but the setbacks on the lot lines and how they relate to each other would also provide a component. So as long as you had, say, for an ADU, the 4-foot minimum setback, that would allow a firefighter to get all the way around from a component of the ability to encircle the entire building for any sort of operations or rescue. Then you would also take into consideration the distance from hydrants. So you'd probably run out of an opportunity to spread this out because of infrastructure, because at that point you wouldn't have a complex putting in infrastructure like hydrants and things like that. You wouldn't be able to comply with the 150-foot standard. So that would probably be a limiting factor here as well. And when you have those projects and individual homeowners faced with having to add a fire hydrant, at that point the project becomes infeasible.
Got it.
If I missed it in any way, the thing is it's an incredibly dynamic scenario. We did see some of this. Brad and I are actually we both were in San Jose. I was a fire marshal. He was working for me in pretty much the same capacity. So we saw a lot of this in downtown San Jose where the density just kind of blew up. So setbacks, distance, where on the parcel the property exists and where each structure will be, and where on the street in relation to services, specifically water, were the biggest components and challenges. So you would run into a dead end with the amount that it could be built out at some point.
Got it. Okay. I don't have anything else immediate other than that I thought that the applicant had something that he wanted to say, and if there's some other answer that he wanted to provide, I'd like to be able to afford that opportunity.
Did you have a topic that you were interested in hearing a response to?
It sounded like there was a question that he wanted to respond to.
I wanted to respond as a rebuttal to the comments. Is that okay to do that now? I believe we had 2 minutes to respond.
What's the topic?
Responding to the public comments.
No, no. So the public hearing is closed. I see no further hands raised, and I'm sorry.
Yeah, I do have one additional question actually for Ms. Lee.
Okay, so we're reopening the public hearing, and please ask away.
If you could illuminate for us, I used to practice workers' compensation. The general standard there for almost everything was substantial evidence. It has a particular meaning there, and I would be curious to hear from you as to what would constitute substantial evidence in this case with regard to the HAA standard and the density bonus law standard.
The substantial evidence standard with respect to approval or disapproval of a project means whether a reasonable person would find, based on the preponderance of evidence, more likely than not, that a project would comply or would not comply with the applicable standards that are required under the law. In a case like this, a disapproval would be permissible under the HAA 65589.5, where it would have a specific adverse impact on public health or safety, and there's no feasible method to mitigate or to avoid that specific adverse impact on public health and safety. And to quantify that, the state law basically says a specific adverse impact means a significant, quantifiable, direct, and unavoidable impact based on objective, identified, written public health or safety standards, policies, or conditions as they existed on the date the application was deemed complete. And that's under, I believe, 65589.5 D2. And so that's the standard with which we're dealing. Hopefully that answers your question.
For the most part. Turning back to staff for a moment, I know I've asked this question and you've answered it in the desk item, but is there such substantial evidence here?
I believe I was paying attention enough before that, but yes, staff does believe there is.
No, substantial evidence to deny.
Deny,
yeah,
no.
Okay.
By the other way, yes.
Okay.
I gather you've finished your questions? Okay. I do have one question for Attorney Lee also. So the issue with the objective standards with regards to the evacuation study, could you explain what we have for a hurdle on that item?
The problem with, and I understand the concern, I will say with this caveat that I represent several cities that are fully encompassed within high fires hazard severity zones. So I understand the concern with evacuations and with fire threats along hillsides and other areas where there is natural brush and a lot of fuel for wildfires. The problem is that under state law, the issue is that we as jurisdictions and lead agencies have to apply the objective, quantifiable, significant standards that exist at the time the application was deemed complete. With respect to evacuations, there's no specific requirement for a type of evacuation plan. And I understand that to a certain extent, fire codes require emergency access, and also evacuations for human life and other life from a site out and onwards. With respect to specific traffic issues and congestion that may be located on streets in the surrounding area, I don't believe that the city has adopted a specific objective measure for an evacuation plan that deals with that specifically. And so as a result of that, I don't think that holding them to a specific standard that isn't quantifiable yet, or that doesn't exist as an objective standard yet within the city, would allow the city to basically deny it just on that sole purpose. There may be additional information or facts that we can look to, but with respect to this, it is a significant hurdle that the city would have to overcome.
Okay. Thank you. And that I gather that's also the same with regards to the hazardous waste on the site?
With respect to the hazardous waste, there are environmental regulations that would be able to deal with this. You know, a phase 1 and a phase 2 can only go so far if there hasn't been sufficient either soil samples or even with the soil samples that are there, if they're not bored within a certain area or within a certain depth, obviously there may be no way to actually determine what contaminants are there or what constituents that exceed standard levels are present until you actually start digging. And that's why even with a phase 1 and a phase 2 that say that there isn't any contaminant or exceedant levels that exist on the property, the minute you start digging and you find something, there are regulations that would require the developer to halt construction activities and mitigate for those contamination issues or remediate the property if and when those constituents or those contaminants are found within the soil. Okay. So in that sense, laws do exist to account for that.
Okay, and we can further condition the resolution with regards to going to Santa Clara County DEH if needed.
If needed, correct. And I do believe that when a grading permit is issued and when the building permit is issued for construction activity and vertical construction, that would be an automatic requirement to the extent that any contaminants or constituents that exceed standard levels are found. Okay.
And so now my board's all lit up here. I still see Councilmember Fruin. Okay, so I've got Vice Mayor, Councilmember Wong, and Councilmember Mohan, and we're still doing clarifying questions. So please try to wrap up so we can move on to deliberations. Thank you. Yes, Vice Mayor, then Councilmember Wong, Councilmember Mohan.
Okay, this is a question about the chimney effect that was...
Microphone.
About the chimney effect that was brought up by the public. So before, if we have 30-foot setback, it dissipates the fire, provides space for the fire crew to work on both buildings. And now with only 10-foot setback, and would the fire-rated wall actually reflect heat, so that it actually create higher heat that make it more dangerous for the wooden fence and the wooden house in the adjoining property? Could we get some answer from the fire department?
Thank you for the question. I can honestly say I've never seen that one before. So I'm going to give you an example from my experience. I've been a firefighter for 28 years. I've been in buildings that were this high, and they were 20 to 22 feet apart. They burned. They did push radiant heat from one to the other. It affected windows only. It never was enough to actually ignite the other side, and I would be very unlikely, based on my experience, from an operational standpoint and anything I've ever seen, for this type of ignition to occur. However, I will say that depending on how much fire and what you're dealing with, nothing is able to withstand combustion at some point if there's enough influence. So I would hope that that would answer that question. That reflective radiant heat chimney effect endangering the neighboring structure is quite honestly not something that I have ever seen happen. From an operational standpoint, once again, one of the very first things that you do is you protect exposure buildings. An exposure building is the adjacent structure. 10 to 15 feet away, think about your normal residential structure, they have about 10 feet separation. That's an important number.
So I guess the question...
Only when it gets under the eaves and it actually has an opportunity to get into the attic is when you see that kind of extension from structure to structure.
And I guess the question is, for the fire-rated wall or construction, they resist fire. Do they absorb heat or do they reflect heat, actually make it more dangerous for
I wouldn't
other?
attempt to answer that question.
You don't know?
I wouldn't answer that question. I don't know anybody that could in the room.
Okay.
I would also say that the action or the behavior that you're describing is unlike any one that I've ever seen at a structure fire, and I've seen some big ones. So when it comes down to it, I would not expect it to create enough radiant heat to have an effect on a neighboring structure that had the setback that was at least 10 to 15 feet away. Also, firefighters would address that other building, and they would make sure that they're applying water in a cooling operation, and they would assign fire crews in order to basically check to make sure that that structure is also without any incident of fire spread. But it would be mainly the eaves, the vents, and some of the other components that you would care about. It wouldn't be the actual rated wall, and I would just see that it would resist. How much it absorbs, I do not know. How much it reflects, I do not know. But this is a good distance to be away.
Follow up from earlier question. For the exception request for 30-foot setback, have you received other such requests before? Or is this the first one you have received?
This is the first one like this that I believe I can recall. Do you have another? Yeah, I think this is the first one that we
So
received
this is
like
the first one.
This is the
And
first one that we've seen. This is
you are
also-
basing experience to decide the same practical effect, but this is your first one. You have no experience actually
absolutely not. That is not a true
reduce
statement.
setback.
So what
from
I'm saying
30
is
foot.
everything that we put in our report that our document that we provided was actually what we used to evaluate. We were using in addition experience. The reason that we haven't done it here is because LRA just became enforceable for 4290 when you adopted it last year. We have been doing it in the SRA, and when it comes to the same practical effect, we have more experience with that as a process. And this is not any, it is very similar to a normal AMMR process where setback or something else is handled. The setbacks for residential structures is something that we've dealt with. And Brad and I actually have worked on zero lot line constructions in San Jose. Those were also things that we worked on in the highly dense downtown areas. So we have seen these
But
before,
not
and that's where the four.
Highly dense downtown area are not high fire severity zone, and you have not handled any project that has reduced from 30-foot setback to 10.
And
or
that's why
20
we
or
evaluated
5
this
or
one
0.
based on the criteria that they provided, using the standards that they gave us within 4290 to apply it. So I would say, no, I disagree with what you just said. I do think that we have the expertise on board at fire prevention. I do believe that I have a certain amount of experience that lends to that some credibility. And I do believe that when we evaluated this, we did it correctly. So we've actually already gone through everything multiple times, and I have not changed my position.
I asked for documentation to provide evidence for same practical effect, but all I got was a 2-page memo that basically repeats the same opinion that was in the ANMR approval. You have provided no evidence that prove same practical effect for the mitigation measures that were proposed.
I regret you feel that way. I've given you everything that could possibly be provided for you.
No, you
can go
didn't
ahead and make
provide
a decision.
any evidence. Only
Very well.
2 pages of opinion.
Then I have provided what we have been able to provide. We've given you the methodology for it. We have tried to explain this, and I think that if there is a deficit or if there's some component of it that you haven't been able to satisfy, then I would say that this is how we worked within 4290. We were provided the basis, the definitions, and we aligned the mitigations that were provided because of the setback.
Thank you.
And
Mayor,
that's what we
can
did.
I ask for more information about the chimney effect?
We are not bringing in members of the public to continue speaking. We are asking clarifying questions. Thank you.
And then I know that from an operational standpoint, the 20-foot was one of the things that you were asking, is there enough room to work? And I would say yes, there was from an operational standpoint. The access for ladders throughout, we're going to be accessing them. I know that those areas that we can. We have looked at all the buildings. We can access, usually it's any 4 corners that you want to be able to access. We are capable of doing that on all of these buildings. With the building heights, we can get to the roofs with our normal complement of ground ladders, and we also can get to the windows with a normal complement of ground ladders on a fire engine.
Thank you. Next, we have Councilmember Wong.
Yeah, some quick questions. This is just in general. What changed about the Linda Vista roads from 2024 to 2026, the vesting date versus now? We have new information, not new conditions. Did anything change there in the evacuation routes? Anybody know on public works or planning?
Just you're asking about the evacuation routes in the vicinity in the 2-year period?
Yep.
I'm not aware of anything, not in public works, but I'm not aware of anything that would have changed with the street network out there.
Okay. And then with evacuation routes, we might not have our own standards, but aren't there state level standards somewhere that which would apply if our city doesn't have anything in place?
I'm not aware of any.
I believe there's some state evacuation routes that are out there, or state rules that apply. Does our city attorney, Pam, do you know anything about that?
Yes, I will. Thank you. I would defer to the fire department since they deal mostly with fire mitigation and requirements. I would also defer to the traffic engineer to the extent that they are looking at levels of service when the roads are impacted by emergency situations such as a wildfire.
Okay. Is there anyone that can answer that? Well, I've got you here. I'm going to ask you a couple questions on 4291, just to be clear. The way 4291 is, and we've been interpreting a lot because nothing has really gotten into the courts yet, but everyone's applying their professional opinion. But 4291 reads directly, lands in state responsibility areas, SRAs, and lands in very high fire hazard severity zones. And so that obligation is tied to land that is state responsibility or somewhere that's really windy. And in 4291, if we look at this, our job in 4291 is to make sure there's defensible space. So if we don't evaluate defensible space, I mean, how do we get away with not having to apply 4291? What is that exemption again?
It will say later on in 4291 that to the extent that a property owner is not an owner, a leaseholder, I'll just read it. It's easier if I read it.
Person who
Section
owns,
B
leases,
of
controls,
42,
operates.
yeah, a person is not required under this section to manage fuels on land if that person doesn't have legal right to manage the fuels or alter property that is owned by another person. And so within 100 feet, obviously looking beyond the property line and looking beyond the building structure line, 100 feet out is clearly owned by other property owners than the applicant or developer. And so to the extent that management of fuels within 100 feet from each side of any structure is required, that wouldn't apply here.
But do you still meet the defensible space exemption then?
The defensible space then falls back to what is defensible space within the property owner's limits, and the setback of 30 feet would be part of that requirement for defensible space and fuel management. And again, if you go back into the fire codes, the layered nuances of that will eventually lead you to fire code regulations 1270.07 and 1276.01, which allow smaller or less than 30 feet setbacks if the applicant or the developer takes care to either do non-combustible walls or other. I think there's a list of 5 items which we went over in detail already.
Okay, I'm still confused, but I appreciate it. Thank you.
Councilmember Mohan.
Yeah, I had a question for the attorney as well, Ms. Lee. You spoke about post-entitlement issues. What does that mean in short? And does it mean what I think it means, which is that between now and by the time the applicant actually applies for the building permit, there will be other opportunities for us to review some of these issues, which obviously have not been answered to everyone's satisfaction today, specifically fire and evacuation.
Yes, with respect to pre-entitlement and post-entitlement. Pre-entitlement means all the requirements and regulations that are applicable now up into the entitlement phase, which is what we're looking at tonight, and when the project can be what we call entitled or approved. After the project is approved, there's additional steps that a developer needs to take to make sure that their project is in full compliance with all applicable laws, including the fire code and the environmental regulations that exist. Those requirements are required to be complied with prior to the issuance of building permits and grading permits and other permits. And that's what we call post-entitlement or post-approval requirements. There are additional requirements that the applicant would be required to meet with respect to fire codes and fire safe regulations. And that's why the county fire department basically said they need to review and approve a final fire protection plan. That would include all the details that aren't already included now at this stage, but would be included and required prior to the issuance of any building permits. So there are more regulations that they are required to comply with, and that pertains to very specific project level details when they submit specific building plans and other types of plans that are required for building permit submittals.
And in your experience, have there been any instances where we've gone past the planning permit and not approved the final project?
Yes, there are a lot of instances where an applicant or developer will submit their building plans. They're deemed incomplete. The plan corrections are sent back to the applicant. They make sure that the corrections are made, and then they resubmit. That process continues to occur until all the checklists and requirements are met, and that's when it can finally be approved for a building permit.
Okay, thank you very much.
Thank you. I think I'm going to share screen here real quick. I'm hoping it'll be quick. Okay. So this is a question for the attorneys. So this was like a condition that I was am considering the environmental remediation and ongoing monitoring. So this isn't something that's in the resolution currently. And would this, is this along the lines of something that would be acceptable? It's basically asking that it goes to DEH, but really spelling it out very clearly. It's from the later item that we have. It's directly from the Mary Avenue resolution.
I think that that is a reasonable condition, and based on what I've reviewed so far of what you've shown on the screen, I believe that to be a condition that complies with the law.
Okay. And then the next thing I'm curious about, with regards to the vesting tentative map, it doesn't show the interior property lines. And I don't know if that rises to the existing property lines from the 4 different parcels are not shown on the map. And the ownership is also not clearly stated for all the percentage of ownership. There is a supplemental map within the supplemental reports that shows the actual ownership. I don't know if this rises to the level of saying that this map is incomplete. If it is, that's interesting to know. Otherwise, this would be a condition to have it fixed within 30 days for staff level approval.
I'll defer to the planning on that, since they're more familiar with vesting tentative map that was submitted in this case, and they can probably speak better to the requirements.
Okay, just for disclosure, this used to be my work.
I don't have the answer. I would want to run that by Public Works, honestly, since it's the vesting tentative map. Yeah, I don't know if there's a requirement to show the existing property lines on the map as well, or if it could be done on a separate sheet.
And council members, Jennifer Chu, Senior Civil Engineer with Public Works Department. So with regards to the vesting tentative map, it's actually a plan set that consists of several sheets. So while the vesting tentative map sheet, TM 1.0, shows the proposed parcels, there is another sheet, C 1.0, that does show the existing lot lines.
So they're combined in there. Okay.
Correct, yes.
Okay, so even though this is the one plan that says vesting tentative map, you're saying that another plan is incorporated into it?
That's correct. And there actually is a sheet index that provides all the different sheets for the tentative map.
Okay.
Package.
And so on the front sheet for the vesting tentative, it has the owners listed, but it is not like the complete from the title report list of the owners with all of their fractional interests. And do you have that on another page?
That is not noted on any other page that I'm aware of. Okay. And I don't believe it is a requirement from the Subdivision Map Act.
Okay, so, well, it should be matching what's in the title report, and the supplemental report does indicate it, which I greatly appreciate. But for me, I would want this to be a correction. I don't think it's a fatal issue, though, for the vesting tentative. I would like to see, and since you're saying this is part of the complete set, I would like to see the bioretention removed from the intersection area and placed go back to a typical section from the city where you have the curb, the parkway, which would be bioretention, and then the sidewalk, to not have that bottleneck. Is that something that I don't know who to even ask this of, is that something that we can request? And along with that request, I would want the cul-de-sac bulb to be removed and for this to be a proper proper hammerhead turnaround with the standard curve onto A Street. I believe you can acquire probably 2 at least parking spaces if they were to remove this odd alignment, and I think it will also improve driver comfort in that area where they're seeing something that they're used to, rather than going down to the end of the street and then seeing it widen out with red curb and then have the odd points at the end with where the hammerhead starts. Is that, who do I ask of that? The applicant, perhaps? Okay, yeah.
So that design was a function of months of review back and forth with the fire department. They specifically asked for that, that turnaround the way it is, the cul-de-sac design. So we're not agreeable to changing the design of the project if it's going to make it unapprovable. And again, I don't know if they're in a position to make a decision on the spot, because I do know that was months and months of going back with them to get the design that we have.
Okay. Do you see the merits of having it be a straight hammerhead and potentially picking up parking? Because you don't have any guest parking.
Yeah, so I appreciate the thought for the design, because it was such a sticky thing and how many months it took us to get something to get fire to approve. I'm not in a position to say yes, because I think so many things impacted this cul-de-sac and the hammerhead to redesign it on the spot here.
Well, that is interesting. So the response that I got to some of my questions is that the hammerhead turnaround is the designated fire turnaround for the project and not the cul-de-sac. So that's in
that is
supplemental
correct. That's
report.
how we started it, just like the compromise on the 2 stories that we had worked with Councilmember Ferrin, just like the non-combustible fence. These are things that we worked with fire department, whether the code specifically required to have 2 turnarounds. We worked with the fire department. Our understanding was that the hammerhead was adequate. The fire department asked us to look at the cul-de-sac to see if we can also have that as a turnaround. And we worked with the fire department just like we have tried to work with every different department to incorporate things that they think makes the project better. So
Okay. Would the fire chief please respond to this? Because I don't really feel that this is something within the fire chief's purview for street design. So you're kind of treading into the civil engineering street design area.
Yeah, so neither of us were involved in the back and forth that took place between the fire department, our plan reviewer, and the applicant in the early stages of trying to get the turnaround design. But I believe that the project was initially proposing a cul-de-sac, and when we look at our design standard for cul-de-sacs and it was determined that the project would not be able to meet that design, that's when the modified hammerhead got introduced. So from our perspective, we are looking for one compliant turnaround, and we don't have an opinion on whether that is what's currently proposed, or if the project were to propose what you're suggesting and just a compliant hammerhead, we would be okay with that as long as it's compliant with our standard.
Okay, thank you. I think it would be much better for the residents, future residents. And considering it is the city's land, I really don't understand why we cannot have a say in how it's being designed. accordingly with the bioretention. Because if you move the bioretention from the front and you use it in the parkway strip area, then you've got the same functional area of bioretention and you don't have the bottleneck at the front, which is something I'm concerned with. And the fire chief has already said that in order to, if I'm going to paraphrase, that if the fire truck is coming from the north to the south, in order to make the right-hand turn, it's going to need to encroach into the oncoming traffic lane, if I understood correctly, which to me is not a good design there either. So I'm really going to push for these two things because I don't think it's really your right to tell us how we're going to design our street.
You want to address that?
Hi, Ryan Hansen with CBG, the civil engineer. There's three parts to, I think, the entrance, the bulb, the bio, and the end. So I'll try to take them in parts. The entrance, as far as the turning, these are 30-foot radii. This is what is required to get trucks around, whether our turning template is shown from the south or the north. It is in compliance. We can get the truck through there, and we do meet the minimum standard. As far as the bulb out location, a lot of this is driven by two things. One, our requirement to treat off-site impervious surface under the new MRP 3.0. Also, when you come around a corner like this, say you're coming southbound on Linda Vista into the court, when you do have parking around the corner, we do like to use these bulb outs as protection because you do get a car that might be right on the inside of the public road. Someone comes around the corner, and so by having these bulb outs, it does give that car a little bit of protection as you come around. If the requirement was to remove it from the inner Evaluation Court area, the alternative would be to remove parking along Linda Vista with a very similar bioretention pocket, if you will, because all of this is treating is the public right-of-way. So given the road design of Linda Vista, we didn't want to have just this one little pocket where parking was going to be removed from Linda Vista. So it not only gave us the protection, it met our treatment requirements, and traffic calming, what have you, we still met the fire department turnaround as we come into the project. As far as the end of the road, I will point out, while we do need the hammerhead and we comply with the hammerhead at the end for fire purposes, I'd also like to mention or note that on daily deliveries, Amazon trucks, they're likely to use the cul-de-sac more often, right? We're talking about an emergency where a fire truck might come down to the end, but this is a public road. If we have this straight off like a hammerhead, like I think you're imagining, anybody who comes down there and just so happens to go to A Street would then have to come onto A Street, which is the private road, use the hammerhead and back out. Whereas I think the cul-de-sac might be a better opportunity for them to make a U-turn, if you will, around the cul-de-sac and then get back out to Linda Vista.
With no area for them to park in order to, because you only have 10 parking spaces for the guests for this project, and very likely it's California. Half the garage is used as a storage cell. So you're probably going to end up with people trying real hard to get the closest parking spaces to their unit and having half their garage filled up with stuff.
So in respect to the garage, this is part of an HOA. It's going to be managed by the HOA, and the requirements in the HOA are that parking garages are not to be used for anything except parking, and the HOA does oversee that, and they do inspections for that. In respect to parking, I do believe we have met the city's requirement for the parking for the project. I think the nuisance of trucks and vehicles going into the hammerhead for deliveries in order to turn around is worse than trying to add few parking spots. We spent, as I said, over 14 months developing this plan and getting it approved by the city, bringing it before you tonight. I don't think it's a right forum to redesign a site plan. It's not that I'm trying to force a design on the city. It's a design that's evolved in working with Public Works, planning, fire, and coming up with the solutions that's here. I just don't think this is the forum to redesign a project.
But you've offered an alternative design with a two-story houses on the edge, which would be basically redesigning at the 11th hour.
That's correct. That's to accommodate council members' requests. That's to accommodate the neighbors. That's a much simpler fix than trying to redesign a site plan that we have spent 14 months with enormous amount of time and effort on staff's part, our consultants' part, to come up with something that works. What you're recommending is redesigning a site.
The street.
That is part of this site.
Which it's a minor,
implications.
Yeah. Okay. So also with regards to this street and the right of way, there could have been a vacation of the street. It's been in city ownership for decades. It could have been vacated and had a more, in my opinion, more appropriate driveway design, which would be with two entrances for the residents. And I regret that could not be done. So thank you. So we are closing the public hearing, and does anyone have a motion that they would care to make at this time for purposes of deliberation?
Mayor, can we vote on the AB 130 exemption separately from make a determination on that first?
Well, I think I would take an easier vote to go first, which would be to look at the trail access.
Oh, okay.
And take that one separately. So I move that we deny the trail access.
Second.
Okay. Do we have any comments on this?
No, I don't. Yeah, I also don't think the trail access is necessary, and also based on the design, it seems could create slope stability issue on the trail, and so there are other issues that might be created by the trail access. So I would rather not. Have
Thank you.
it.
I think these are new requests to speak. Councilmember Fruin, and then Councilmember Mohan.
Yeah, I think that the trail access would actually be a very nice public amenity for the neighborhood. I think it's unfortunate that it's looking like there's not consensus on that.
And Councilmember Mohan.
Right. I sort of wanted to echo what Councilmember Fruin said. I thought the trail access would make sense. I've actually looked at it and saw how it connected with the Linda Vista Trail. And if we do it now, it will be less costly than when we do it later. And in the big scheme of things, it's not such a big deal. But, and of all the issues we've discussed today, this is probably the least consequential. But just from my personal point of view, I like trails, and I thought this was a sort of a natural connection between the property and the Linda Vista Trail.
All right. Are we ready to vote on this item? Madam City Clerk, will you please set the vote?
The motion is to deny, right?
Yes means to deny.
Yes means deny.
The motion carries with Fruin and Mohan voting no.
Okay. So next we have some more challenging items to look at. I do wish to ask, should we make a motion in order to have the the issue with the ownership clarified on the vesting tentative map to match the supplemental materials. So I would like to see that changed on the vesting tentative map so that it coincides with the supplemental materials that staff provided. And I'll scroll to that so you can see it. Okay, so I need to screen share. Okay. Here we go. Okay, so this was provided by staff, and it shows the 4 parcels. And here's the actual ownership for each of the parcels. So since the property lines they apparently show up on a different plan, but on the cover sheet you have the ownership. So my motion would be that the ownership matches that which was provided in the supplemental report. And it would need to be showing the assessor's, just like you see here, showing the assessor's parcel number, and I like that it shows the address and who owns what. So assessor's parcel 356060001 would show up. It would be a little table that would be added. I like it because it makes it more precise.
I would support that, but I hope we vote on the AB 130 first. If we agree that would pass, then we go on the project approval. So it seems we should make a determination on AB 130 first.
Okay, make your motion then.
Okay. I'll make the motion to find the project not exempt from CEQA. I'm sharing my this is a document from David J. Powers for the AB 130 CEQA exemption. It's very insufficient. The reasons it listed that a project can be located within a very high fire severity zone if it adopts fire hazardous mitigation measure. Nowhere does this even mention the building code that the city adopted in November. And then it goes on to say the project would implement various strategies and measures. But these are the various strategies and measures that was proposed to get the reduction of the 30-foot setback. And according to the fire chief, they did not check the justification to even allow reduction of the 30-foot setback, which according to the government code says it shall provide evidence. I think I need the language somewhere. It's I think the government code says that it shall be based upon practical reasons, which may include but not limited to parcel dimension and density requirements, and other site restrictions, but none of those is economical reason or design choice. So I don't think this the 30-foot setback reduction should even be allowed, and that means the project does not comply with adopted mitigation measures. So it shouldn't be allowed to be exempt from CEQA. And the city also does not have any adopted mitigation measures to allow any exemption for very high fire severity zone. That's on the record. So that's my motion.
Can you reread your motion one more time?
Oh. The motion is just to find the project not exempt from CEQA per AB 130, because
And that's it. That's clean.
That's it,
Okay,
yeah.
so make sure. Okay.
the others,
Okay, I'll second that.
do I need to include the reasons?
You don't?
Can I ask a quick question about that? Maybe the attorneys can tell us what would be the consequences of not exempting from CEQA?
The approvals that are being requested here would not be approved, and then it would be up to the applicant to, take legal action against the city to get approvals.
To the mayor, I have a question for the attorney. Are you done with your question, Councilman? Okay. Oh, we're trying to get a clarification? Is that what people are asking? Okay, so the question was, I think your earlier question was, what's the consequences if we don't approve the exemption from CEQA? And then my question to you is, what are the consequences if we allow 800 residents to be in a severe fire with no evacuation routes? That's the other question.
A legal question?
Is there a legal ramification for us making that determination? Because we're being asked to choose between two really bad questions, right? And some of it's less worse, right? Toxic chemicals, fire safety risk, and almost 1,000 lives at risk versus a housing law that's theoretical. I mean, it's a law, but it's theoretical that it's okay to put people's lives in risk in a fire zone. And so that's the question. What's the legal consequence for us making a decision saying this thing is exempt, and then we have a huge fire and 1,000 people can't get out? That's my moral obligation and question that's going through my head right now.
Understood. The city would be immune under Government Code 818.4. The city's legal immunity would apply.
The city is immune, but so legally it's okay for 1,000 people to be at risk, is what we're saying.
I'm not saying that. I'm saying that
The law might be saying that. I'm not saying you're saying that. I'm saying the law might be saying that. So that's okay. I just wanted to get that clarification.
If I could just
Hold on, we're getting out of order. Councilmember Fruin, and please, if you've spoke, clear the queue out. Okay, thank you. So Councilmember Fruin, Vice Mayor.
Thank you. So
next.
again, in clarification, a denial of the AB 130 exemption is a denial of the project. It's also independently a violation of the Housing Accountability Act that would entitle not just the applicant to sue, perhaps they walk away from the project. That doesn't mean that we're off the hook. Both HCD, the Attorney General's office, and any housing advocacy organization can still sue the city and would. If the housing element is decertified, which I think seems incredibly likely, especially based upon Governor Newsom's comments yesterday for those cities that don't currently have a housing element, then what you're looking at is builder's remedy projects all over the city. So this is a Pyrrhic victory if what you're thinking is that you'll just stop one project. It could also just be approved by a judge. That would be another consequence. So you lose all the money from all the fines and fees, which are on an order of magnitude of millions, and the project still gets approved. You've solved nothing. If you want to use our public resources better, and if what we actually care about is the public safety, it's very clear from the health and safety element revision that we're working on right now that there is a lot of concern that we already have based upon the current state of affairs. So we should be allocating our time and resources on enacting policy that helps protect the whole community, not just from a project, and making certain that we're hardening the space for the future, because the fire maps will change again. I mean, Saratoga, for example, used to be at least half all in very high fire hazard severity zone. Cupertino now has a little bit more. The next time that the maps change, who knows exactly what the situation will be. We can spend money through the budget process, money that we would otherwise throw away on attorneys and fines and who knows what else, and spend the time that we should on trying to make this space safer. So I think that we do more things through the health and safety revision, and we add some money to actually create better hardening in this area. That's what I think that we do. That's a much better stewardship of our public resources, including the money in our general fund, which we can ill afford to use right now based upon what our budget outlook is. So I think this is a fool's errand to deny this project on this basis.
Okay.
Vice Mayor?
So I understand I think our obligation on the city council is to obey the state law, the law as written. And according to the law of AB 130 as written, I couldn't find sufficient evidence from the record we have that we have adopted the mitigation measures so that we can exempt a very high fire severity zone. I understand the HCD now has a tendency to make their own interpretation of the law, unfortunately. I would like to clarify for the Builder's Remedy project that the city denied. It was determined, the decision was made solely by the former city attorney, Chris Jensen, without consulting with any council member. It was solely his legal interpretation that the applicant should not have a limited number of 90 days to resubmit project until they complete the application. And that's the common interpretation of any law. But unfortunately, HCD is trying to override this common sense interpretation of the law by now instructing the cities, and the court is following that they can have a limited number of 90 days to submit an application. So I understand our risk of just following the law as written because we have a super agency now somehow was given the superpower by the legislator to make up their own interpretation of the law on the fly. Should we just then be so scared and try to not follow the law, but follow the maybe interpretation of HCD? I don't know. Then what that makes us? Scaredy cat that doesn't follow the law, but we follow a super god who wants to just approve every project regardless of the safety of the community. I think back to the question of Councilmember Moorhead, if we find the project not exempt from CEQA, that does not mean denying the project. That simply means we would require a CEQA process for the project. And that does not mean the project cannot be built. The project definitely can provide 30-foot setback with small, actual starter homes. Like many of the speakers who support the project says, we want to provide more starter homes for young people who are starting. Who start with 2,000 square foot, 2,500 square foot 4-bedroom as a starter home? No one did that. That's usually a second or third home. So we are not saying denying the project. We are saying do a CEQA process and give us the project this site was intended for. Smaller starter homes with sufficient setback for fire safety. There will be sufficient profit, just maybe not as large as a 4-bedroom townhome project. But 2 to 3 bedroom townhome project will actually be more affordable for young families. And these are the kind of homes we need in Cupertino because we have so many 4-bedroom single-family homes. But we don't have as many 2 or 3 bedroom, even smaller 4-bedrooms. We don't have them. So we need them. So finding the CEQA, denying the CEQA exemption under AB 130 does not mean we don't want housing on this project. We want them. We want the kind that actually meet our housing goal, which is to provide housing that we are missing.
Thank you, Vice Mayor. It seems, though, that you're asking to have a redesign of the project, and I would personally be looking more towards a quantifiable health and safety impact, which is, really how I've been spending my time. So first looking at the evacuation study, then looking at any issues with the vesting tentative map, and then, of course, as you've heard, going through all of the environmental site assessments in the process, which the owners went through. So I'm not hearing that you have a quantifiable health and safety impact. So my concern there is that, I had hoped that with regards to the evacuation study, that there was a potential that we could use SB 131 for a limited focused evacuation study. And there, the problem is we don't have objective standards to meet, even if that evacuation study is conducted. And so that's the challenge there.
May I respond?
Please.
Yeah. That's a very good point. Actually, the missing adopted mitigation standard adopted by the city of Cupertino to allow exemption under AB 130 should include the evacuation study, objective standard. So I guess I'm happy to amend the motion to include a direction to the staff and then, or maybe the applicant, to bring us a project that contains smaller units to provide starter homes for Cupertino, and for the staff to quickly adopt actual mitigation measures for very high fire severity zone, including evacuation analysis and study. And then perhaps objective standard for reduction of setback when necessary. I think the fire department can adopt their own standard for setback. The city can adopt also a more stricter standard. Right?
If I could chime in, Vice Mayor Chow, the motion that is on the table now is with respect to whether or not this proposed project complies with or is applicable for a statutory exemption under AB 130. I believe that the staff and the written materials and the oral testimony thus far have indicated that there are sufficient grounds and substantial evidence to indicate that there is the availability of compliance with AB 130. With respect to the hazard mitigation measures, I can't speak to a specific hazard mitigation plan for the city, but that is very distinctly different from hazard mitigation measures with respect to a 30-foot setback, which is already codified under state law, which has already been adopted by the city. And it lists out options to mitigate the reduced setback requirement. So those are not additional mitigation measures that the city needs to adopt. Those already exist under the state law, which has also been adopted by reference under the California Building Code and the fire safe regulations. If we're talking about a hazard mitigation plan, that is a very different aspect. That is not the topic of today's conversation, but certainly you can direct staff to do that or update that as well. But I think the motion on the floor is only with respect to whether or not this project complies with AB 130 such that it meets the statutory exemption.
No,
The
I
project
didn't talk
redesign-
about plan. That's not what I said. I did never mention any hazard mitigation plan. AB 130 says sites that have adopted the mitigation measures. And so the city did not adopt mitigation measures for high fire severity zone, period. We don't. Where is it? The staff pointed me to the building code adopted in November. That turns out to be building code that satisfies maybe Chapter 7A to be consistent with the county fire. It's not adopted mitigation measure to exempt a project from CEQA for very high fire severity zone. If you disagree, where is it? Show me the evidence. And therefore, my amendment to the motion is to direct the staff to bring us proposed mitigation measures for very high fire severity zone we may consider to adopt, but they don't exist today. As for the 30-foot setback, yes, the law does allow reduction of 30-foot setback if there is practical reasons to justify for it. But even when there is practical reasons, there is not objective standard or limited. There is only some suggested measures. So for that, there is actually also no no adopted mitigation measure for 20-foot setback, 10-foot setback, or 0. There is none. The law does just says reduction could be considered if the justification is met. But what is the reduction? That we never adopted it. The fire department says that they base that on experience. That's not an adopted mitigation measure. And that's discretionary also, and case-by-case basis.
Related to that discussion through the mayor?
Sure.
So I'm a little confused. I think the attorney at SummerHill said they claimed compliance with 4291. So it must be relevant. But then if SummerHill has accepted that 4291 is needed and 4291 requires a 30-foot setback, do we not need that at all? Is that what we're saying? So I'm not asking you, I'm asking the city attorney, but sorry about that. Yeah. No, because that's what we saw in some of the documentation. That's why. So Pam, I mean, do we need it or we not need it to certify, to figure out if we're exempt from CEQA or not exempt from CEQA? That's where my confusion is. Mary, you're shaking your head. Why is it?
Okay. Let's take it step by step then. AB 130 is codified under Public Resources Code 21080.66. 21080.66 basically states that to be exempt from CEQA as a statutory exemption, it needs to meet all these requirements. And it lists the requirements, I believe.
There were three, right? 4290, 7A, and 4291, right?
There were like 8 requirements. You know, it has to be in an urban area, it has to be an urban use, All those other requirements are not at issue. The only requirement from today's hearing that I understand is at issue is whether or not the project is within a high fire hazard severity zone. And if it is, is there enough that allows it not to apply because there are fire hazard mitigation measures? Not necessarily CEQA mitigation measures, but fire hazard mitigation measures that are in existence, that there's a list that you can take for mitigating your chances of your structure catching on fire or having an adverse impact as a result of a wildfire. Those are codified in the existing building code under 7A of Title 24 of the California Code of Regulations, which includes the fire safe regulations that the fire chief and assistant chief have alluded to and actually provided in detail in writing, as well as the oral testimony that you heard today. Those fire hazard mitigation measures are listed out in that code, which has been adopted by the city. One of the options for fire hazard mitigation measures includes the list of items that they can implement as part of their project in order to get a reduced setback. The setback requirements are codified under section 4290 and 4291, right? Which I'll speak to. Chapter 7A, which includes the fire and building codes, and those sections.
Mayor, excuse.
No, silence, silence. You're disturbing the meeting.
Okay, so I will continue. And based on those fire regulations as adopted under the city's code, as codified under Chapter 7 of the California, 7A of the California Building Code, the applicant has taken measures to mitigate for the fire hazards in accordance with those regulations. And specifically with the 30-foot setback, they've taken steps to either implement non-combustible block walls or fences, or non-combustible materials extending 5 feet horizontally, or hardscape landscaping, or a reduction of exposed windows, or more protective measures that are codified under the code. And those are a list of options. And I know that we talked about whether it's, based on practical reasons that they're allowed to do this. I believe that the record is clear that the practical reasons would include certain site constraints that the fire chief had already discussed. So those are the fire hazard mitigation measures that are talked about, that are specifically referenced under the Public Resources Code and AB 130, that are currently implemented as part of the application. There's no mitigation measures under CEQA that are separately codified other than what's already listed.
Right. Thank you. Next, we have Councilmember Fruin, Councilmember Wong, and then the Vice Mayor.
I'm out of queue. I'm taking myself out.
Oh, okay. Councilmember Fruin.
Yeah, just a quick comment to remind everyone that independently, a denial of a CEQA exemption for which a project is eligible is itself a violation of the HAA, which triggers all of the consequences I described before on its own. Doesn't matter. It doesn't get you, even if it gets you an EIR, it doesn't solve the fact that we still get sued, we still lose a ton of money, and we don't solve anything that anyone's concerned about. It's the most impractical solution that I could imagine. In addition, the clear advice from the city, both our planning staff, the fire department, and the city attorney, is that yes, this does in fact meet the standard for AB 130. So I don't know how a council member with no legal training is going to speak against the city attorney's own view.
Vice Mayor.
Okay. So the city attorney and Attorney Lee has not still has not provided any city adopted mitigation measures that for this site to address these 3 items, including but not limited to, which means we could adopt mitigation measures for evacuation study on evacuation route, but we haven't done that. And but I'd like to point out for Councilmember Wang, Section 4291, which I think address defensible space vegetation and post-development maintenance. That applies to state responsibility area SRA. However, you see here it also says Section 51-182. So that is a comparable section for local responsibility area that address those 3 issues. So whether it's state responsibility or local, both need to have adopted mitigation measures for all this, but all we have from November 2025 are building code that satisfies Chapter 7A. We didn't adopt anything for item 1, for section 511A2, and we didn't adopt anything for section 2, for section 4290. And we could adopt that something that follow this and further going beyond that to exempt CEQA for very high severity zone. For example, we can say that the setback should be no less than 20 feet, for example. That could be an objective standard that we adopt, but we never had that discussion at all so far. So that is the reason Cupertino as a city don't have any sites that have adopted fire hazardous mitigation measures that address all three of the items listed. If the attorney, so I'm not convinced by the attorney's argument.
Just clarification through the mayor. Vice Mayor, you're saying we're not following the law because we have not adopted Section 1, Section 2, but we've only done Section 3. Is that your argument?
Yeah.
Okay, just wanted to be clear.
May I address that? The odd language where it says the site adopted these measures, I think it's suggesting that it doesn't have to be the city who adopts the measures, but that a body that has the authority to adopt the measures has adopted them and they applied to this site. That is my understanding. And so that's why I posit that these factors have been satisfied and the exemption applies.
But through the mayor, the city attorney, that means these have already been adopted, not about to be adopted, not planning to be adopted. They've already been adopted is how that language reads to me.
Correct.
When did we adopt any measure for item 1 and 2?
I believe the state adopted those.
State adopted, but we didn't.
And I don't believe that the statute requires that the city adopt them.
It says sites have adopted.
Correct. No, it's that, that sites have adopted, which is odd language.
And then the document prepared by David J. Powers says it adopts, present tense, now. And then didn't say adopt anything, and then just say, okay, here are a list of measures. That's actually is a list to mitigate the 30-foot reduction, setback reduction. So it's there is very inconsistent on record that's in front of us. Yeah.
I will add that I'm not sure there is a way for a site to adopt a fire hazard mitigation measure other than to include a fire hazard mitigation measure as part of its application and its plan that's submitted to the city for review and approval. That is the way a site adopts measures to mitigate fire hazards.
The city has to adopt it, not the site. They can propose. They can propose. The city can approve.
The city has already adopted plans that allow for a laundry list of fire mitigation measures. And that was through the building code and the fire code and the applicable fire safe regulations. And it's up to the applicant to determine from that laundry list of potential fire hazard mitigation measures, which ones would be most applicable to their property. And that is what they've done here.
But the city didn't. I think the November adoption of the building code is relevant to Chapter 7A. I looked at the ordinance we adopted in November 2025. It did not mention 30-foot setback. It did not mention defensible space. So we have not adopted anything for item 1 or not item 2.
Yes, these specific regulations are actually codified in the fire code as well as the building code. 4291 talks about those that are in the state responsibility area. 4290 talks about those that have a certain area, maybe the local responsibility area, and how they're supposed to maintain defensible space. The regulations talk about exactly what types of defensible space and the mitigation measures that are required. Because if you look under subsections B, C, D, under both of those sections, it talks about the state and the state fire commission adopting codes that specify how these mitigation measures or how the fuel modification can be accomplished.
Yeah, but if it's only sufficient, if it's sufficient for the state, just the state to adopt this standard, then the legislator could just wipe out this whole section, because every site in California have adopted the fire hazardous mitigation measure. Why even include this whole section? So that cannot be the interpretation. That cannot be the legislative intent of the legislator. As long as the state adopted mitigation measures, a site can exempt from CEQA. I don't think that's the legislative intent. The legislator wanted to exempt high fire severity zone.
Earthquake.
Oh my God. And we just said that there is no active fault line near us.
Earthquake detected. Yeah,
We need to evacuate.
it's emergency alert on my phone.
We have to?
Drop, cover, hold.
Don't run outside in earthquake. No.
Drop, cover, hold.
Pardon.
You're under all this equipment.
Yeah, so we
You
duck.
might wanna
So we duck.
duck.
Okay.
I would go out.
Would the fire chief care to comment on your best suggestions for what we do at this time?
He's under the door. He's in the best spot. We're under trussing here and lights that are going to hit us. So. USGS, anybody? Go for it.
I'm going to continue.
Yeah, that's
Okay. We have to get to Mary. I'm sorry, folks. We're going to keep going. You're all good? Everybody good? Have some pizza? All right.
Nothing else is open right now, just so you guys know.
Okay, so
And wrap it up.
we're all good?
Let's try and wrap it up quickly.
Okay. Okay, so with that line of questioning, is Attorney Lee still on?
I'm still here.
Okay, so we had an earthquake. I am kind of wondering about when we're looking at like AB 130 and AB 172 and density bonus law, Housing Accountability Act, fines and penalties. Is this, in your estimation, is this really a discretionary decision still for us? Because I feel somewhat cornered.
You are required to look at the project and see if it meets all of the quantifiable and objective standards with respect to the project. And so in that sense, your discretion is very limited to those standards. Going beyond that would be outside of what's authorized under the state law according to the state legislature. I'm not making an opinion on whether that is correct or not, but that is what the law says.
Okay, thank you. And I feel like this is kind of a culmination of when I first started on the Planning Commission and we had the first density bonus law project, and we were handed a memo from the applicant's attorney. That was in 2019, and this just feels like it's continued on in that same vein. And so it's for the planners. I don't think that this is a great fund for for you and for the councils, all of the councils across the state. This is a huge issue. It's created a lot of work for attorneys in land use and for consultants working on the housing element, but for the councils, what we're seeing is that our state legislatures are passing laws that they don't need to sit in a council meeting and listen to upset residents. They're off in Sacramento and don't have to feel the consequences of this. We do. And it's been, a pretty painful 7 years of this. Now, with regards to not having a city-conducted project-level evacuation plan study, I should say, for this project, I would like to see it, but without the objective standards for what the results would be, I don't know what the merits of having such a study would provide us with, or if we were to enact some kind of standard for it, I don't know who we would be able to model it after. What matters? 2 minutes, 5 minutes, 10 minutes, 30. How does that work? But while we do have the fire chief here, and this is something that we're discussing, please log into or sign up for Genesis and for SCC alerts, because Genesis will, for evacuations, help bring you out, that you'll be given directions on where to go to evacuate from your area. And that will make the difference, because if we only have like 15% of our city signed up for it, and you need to evacuate, you're going to want to have directions. Otherwise, you are going to force your own bottleneck if everybody chooses the same route in a neighborhood. So I don't see any further requests to speak. I've got one more, Vice Mayor, and please make it brief so we can wrap up and vote.
I hope to amend the motion a little bit so that it's more defensible. The motion was to find the project not exempt from CEQA. And I'd like to add to that and direct staff to examine potential fire hazard mitigation measures to adopt for under item 1, section 4291 or section 511A2, and item 2, section 4290 for the setback. And I understand we already have building code for that addressed item 3, but I don't think we have 1 or 2. So direct staff to do that, and also to consider a project with smaller units so that we have starter homes to meet the housing element goals.
So to clarify, what duration do you want staff to come back with that 4290 and 4291 request so that they have a policy in place?
We
You don't want to leave that open-ended?
Yeah, open-ended.
You're leaving that open-ended?
Mm-hmm.
Oh, okay.
Because we don't have to adopt it.
Mayor, I think that for that motion, you should have also include a finding that the lack of an evacuation plan today is a potential health and safety risk.
Yeah, and then, so the lack of evacuation plan and study is health and safety risk. So we also, when we consider adopted for potential fire hazard mitigation measures, we should also consider evacuation routes and standard.
I would support that because that would force us to put into the administrative record that we are for affordable housing, we are for more housing production, we're for starter homes, but we also want to make sure we have an evacuation route and we are for fire safety. Is that what you're saying?
Yeah,
Okay.
and then also that when we consider this mitigation measure, I would like to have objective standard on if we reduce 30 foot to 20 foot, what measures are sufficient. There should be more clear standard, not just whatever you propose, I'll check from my experience. That seems to be not very clear. I think we want more clear standard for the applicant also. If they want to, they have to reduce. But then also the justification, you have to provide real justification, right? So those can be considered in our fire hazardous mitigation measures.
Can we simplify the motion a little bit?
Those, you don't need to include that comment. Those, yeah.
Okay, I'll accept your friendly amendment for the purpose of moving things along.
Yeah, okay.
Can I make a quick comment? By including all the conditions that you listed, Vice Mayor, we are basically saying we're not approving this project, which
no, we are
means
not
that,
saying we are not approving.
Okay, then we are approving the project?
We are finding the project not exempt from CEQA.
What does that
mean? And we would like to encourage a project that comply with that would provide more, that follow the law for defensible, for setback.
I agree. I understand all that, but we have, we need to act today. And what we need to do is approve this project or deny the project. Isn't it as simple as that, Madam Attorney?
Yes, it is as simple as that. The deadline is now, and so either you approve the project or you deny the project. And by determining that it is not exempt from CEQA, that CEQA applies, you are basically denying the project.
It's not necessarily true.
Aren't we just postponing it until we have CEQA?
We're asking that it meets CEQA.
Well, the applicant has the right to have a project approval in this time frame. And so if we don't provide the project approval in this time frame, then it will be up to them to take the next action, which is to enforce their right to have a project approval.
But are we saying they have a right to just an exemption without meeting the requirements? That's basically what we're saying right now. We're just saying, go for it. You don't meet all the requirements. We'll just make you exempt. I mean, that's kind of what we're saying. I think what the Vice Mayor is saying is, are we following the law? And you know, it's up to interpretation is what we're hearing right now.
I will add that
Thank you.
There is a shot clock provision under the Subdivision Map Act, and there is a deadline under the housing laws that require the city to make a determination of approval or not approval. Determining that the project is not exempt from CEQA and requiring additional environmental review would require the project applicant to go beyond the shot clock and the deadline that is authorized and required under housing law and the Subdivision Map Act. That being the case, if it's not actually approved, it's deemed disapproved within that time frame, which would then set the motion for various potential legal actions. Just even without the shot clocks and the timeframes, the applicant would be able to do a legal challenge on the decision alone that the project isn't applicable under AB 130.
Councilmember Fruin?
Yes, I'll just hasten to, Attorney Lee already, referred to the provision of the Housing Accountability Act that I wanted to raise again, but I will hasten to add once more that the advice from our own city attorney, from our own planning staff, and from the fire department is that it does meet the standard. This is not just a matter of, one person's opinion is this and another person's opinion is that. There are professional opinions who, for people who have gone through an awful lot of training in order to be able to do this work, and I don't think that a non-attorney opinion on a legal matter for someone with no legal training at all is better than that of multiple attorneys.
Pardon? Madam City Clerk, I believe we've finished our comments. Will you please
Call the question.
What is the motion?
would you like to restate the?
I was going to ask Vice Mayor to restate
could
her
you-
friendly amendment. This,
Could you show maybe your note for the motion?
so I took from the transcript your friendly amendment. Again, this is
Can you
word
share
for
the
word.
screen? Maybe that would be easier.
Okay. If this is, sorry, this is my makeshift draft minutes. So the Chow moved and Wong seconded to find the project is not exempt from CEQA per AB 130. Friendly amendment. Chow made a friendly amendment to add potential fire hazard mitigation measures to adopt for under item 1, section 4291 or section 511A2, and the item 2, section 4290 for the setback. And you understand, these are your words, Vice Mayor, we already have building code for that address item 3, but I don't think we have 1 or 2, so the rep staff to do that, and also to consider a project with smaller units so that we have starter homes to meet the housing element goals. Wong accepted the friendly amendment, so that was your words.
Let me write it more clearly.
Thank you.
I would like to add, that was a friendly amendment to a motion that also included findings on health and safety risk associated with having no evacuation plan.
Could you restate that?
Yeah, maybe if we're, let me just,
We're cleaning this up, yeah.
I'd like to read the appropriate language into the record. If I can find it quickly.
And pardon, just to clarify, the finding that the lack of an evacuation plan, you mean at a project level?
Site level, we'll use their words.
Yes, exactly. And so it would basically be that there's no feasible, specific adverse impact on the health or safety of the community due to the lack of a specific evacuation plan unless the project is disapproved.
Assessing that.
Pardon, but this is a single issue, so it seems that would allow it to. If this were true, it would allow it to use SB 131 for a focused EIR or MND review, focused CEQA review.
Well, that's a good question. I might look to Attorney Lee to address that. But the statute does require that you make the specific findings of adverse impact on health and safety.
Okay, so we're saying that there's a lack of an evacuation plan, but there is no specific finding with regards to that to be made because we don't have any objective standards to, even if we had that study, there's no objective standards that we have in place for it, which, yeah, so I've
that
wondered
makes
about
that a little bit of a flawed reason to disallow the project. Other things that I've heard are we believe that the fire mitigation is not robust enough, and that's why we have a unavoidable risk of health and safety. Or, I mean, you have to identify what's lacking and equate that to this unavoidable risk to health and safety to potentially survive what's required by the Housing Accountability Act.
Right. Yeah. Okay, thank you.
you still,
Okay.
I was just going to make one final appeal to everybody here. I mean, we have a law that clearly states something. We have professional opinion that says this might happen. We have residents that are at risk. I mean, that's not an easy discussion or decision for anybody here to make, just to summarize where we are. If we say we deny the exemption to CEQA, at least we get the environmental protections on the back end, we hope, so that, you know, if there's something wrong with LUS or something wrong with the site, there's hazardous materials that's covered. Plus the second piece is, you know, we at least have to get the mitigation routes in place. So those are two things that are important to me, but I'm not sure if you guys are on agreement.
Pardon, well, Chapter 17 of the Municipal Code covers the any environmental issues, and we saw this with the United Furniture site, which still has over something like 3,000 micrograms per kilogram of PCE still there, still doing cleanup, and even with Valco's got a VIM system going in for their first block, number 5. So they have to put a pipe network in to clean it up. Also bypass CEQA. It's just continuing on that way.
I have another idea. You could make the motion simpler with the idea that if it passes, then the council will then make findings that support the passage. In other words, you could just keep the motion as simple as find project not exempt from CEQA per AB 130. That would be the first question that the council could vote on. And then if the council votes in favor of that, then the next question would be, council, what are the findings that we're now voting on that support that?
Mayor, I have my friendly amendment written up.
Sure, Vice Mayor.
So here is the friendly amendment to the motion, the original motion. That's more clean. Sorry, it keeps us. So here. This, okay. Direct staff to bring back proposed fire hazard mitigation measures to include, but not limited to, Section 4291 or Section 511A2, Section 4290, and evacuation route and plan. Find significant health and safety issues due to lack of evacuation plan and unjustified reduction of 30-foot setback. Is that good? And encourage smaller starter homes at the site for young families to meet the housing element goals to affirmatively furthering fair housing while meeting fire safety standards. Yeah.
What is that amending exactly?
Amending the primary motion to find the project is not exempt from CEQA per AB 183. Per AB 183.
Even though our attorneys have said that it meets the qualifications for AB 130.
Correct.
Okay.
Because
My recommendation is to separate out those amendments. I think they're not necessarily related to the finding that the project is not exempt under AB 130. Maybe the reason that you're saying that the project is not exempt under AB 130 is that the site failed to adopt specific fire hazard mitigation measures in accordance with the requirements under Public Resources Code Section 21080.66 and Government Code Section 65913.4.
Yeah, I think the first item I added for adoption. So the staff to bring back proposed mitigation measures for adoption. Because
Right, that's
the
part of
reason is
direction
we
to
don't
staff.
have adopted mitigation measures.
A quick question. Could this be a post-entitlement issue?
No,
If you're
that's the
looking to
requirement
find that
for
the
CEQA.
project is not exempt under
AB 130.
CEQA, that is not a post-entitlement issue. That is a project level a requirement.
Sorry, we're having a
we did
discussion
raise that.
before. Are you saying it is not a post-entitlement issue, Pam?
You're talking about right now that the project is not exempt under CEQA, which means that there needs to be an initial study and an environmental review determine whether any other exemption exists. And as a result, the project cannot move forward until that environmental review occurs and is completed. As a result, you will not meet the deadline for April 4th for this. That's the only thing that's on the floor right now. Everything else in those bullet points is secondary to this finding or this motion. Directing staff to bring back an item, that can be done by consensus. That doesn't necessarily need to be part of this motion. This motion is specific to the project.
Yes, but I am including them as part of the motion so that the motion is more defensible, because the item 1 specifically points out we don't have adopted the fire hazardous mitigation measures. So we are directing staff to bring that back, and that should include the evacuation route and plan, and we haven't done that.
Can we require that before the building permit is granted?
No,
And also,
the applicable standards are measured from the time the application is deemed complete. And so no matter what you do now, it's not going to apply to this project. That's separate and apart from AB 130. That is because they applied under a separate section of the housing law, under the Housing Accountability Act and SB 330. The application is deemed complete. All the standards that are applicable are as of the date the project is deemed complete, or the project application is deemed complete. So even if you do one now, it's going to apply to all future projects, but not this one.
So I was saying that these 3 items I think are necessary, because item 2 point out that we have reduction of 30-foot setback based on justification that does not comply with the law. So it's an unjustified reduction, and that creates fire and a safety issue. And item 3 points out the density for this site ways that meeting the fire safety standard is possible as long as there are smaller units. And these are the kind of units that actually provide starter homes for young families and better actually meet our housing element goal better, because it provides variety, the missing middle housing that we don't have in that neighborhood. So I thought these 3 supports on the main motion. Can vote. If it doesn't pass, then we can talk about the approval.
Councilmember
You know,
Mohan.
if we're talking about encouraging smaller starter homes, that cannot be for this project. We're talking about another project. I cannot see the value in listing number 3. It's a whole new project you're talking about, Vice Mayor.
Well, if the project provides smaller 2-3 bedroom townhomes.
Yeah, but that's not what we have in front of us today.
Correct.
That is correct.
But the justification for not meeting the 30-foot setback is.
A project redesign is not justification for denying something under AB 130 or under the HHA, under HAA.
Thank you. I believe we've exhausted the deliberations on this motion. Madam City Clerk, will you please reset our vote panel and we can vote now?
So what are we voting on again?
Oh,
No.
the motion. Let me share it. So the main motion plus the friendly amendment. We're voting?
I don't have a vote for Councilmember Mohan or Vice Mayor Chow. Okay, the motion fails with Chow and Wong voting yes.
Okay.
There was that was a substitute motion. There is another motion on the table prior to that having to do with vesting tentative maps.
I didn't have a second.
Ah, very good. Thank you.
You want a second? I can offer seconds.
Okay, so this was just to add the extra information regarding the ownership of the assessor's assessor's parcels per the supplemental report provided by staff.
Okay. It's an easy one.
Yeah.
Should we just do a motion to approve and then add all these additional amendments?
Probably need to pull up the agenda and look at the recommended action
And we haven't approved it yet either.
to see how it's written up.
It reads, find the project exempt from CEQA, make the required findings of no net loss, and approve the following permits: tentative final map, architectural site approval, and tree removal permit.
So we could parse out the tentative final map, but in order to do that, we would still need to do the CEQA exemption. And I don't see any particular added value in doing that. So I think it would need to, we can approve the tentative final map with the amendment that the additional ownership information is added per the supplemental reports. I think that's clear enough. But we would need a motion for this. Vice Mayor, your hand's raised.
So do you want to parse out the different part of the motion?
No, I don't see that I don't think it's going to add anything to separate the ASA from the tentative final map.
So you want to do them all together?
I would do it all together.
Okay.
With regards to the tentative final map set, I still don't like the roadway alignment that we have there. I don't know if I have any support from the council to try to make it be some other way. We could discuss that. The applicant is not interested in it, in making those changes, but I do think that it would be a better layout to not have it the way it is designed.
Okay, so I'll make the motion then for the recommended action. But because I have a few other things I think we need to include. So, let's see. So here is a recommended action, and we are not including the trail access, right? No. And then we want to remove the truck access restriction to the frontage of Linda Vista Road that they have requested, and we would like to add a non-combustible fence, perimeter fence, right?
Yes. That's, by the way, it's condition 85, I believe.
And then add parcel ownership information to the
Per the supplemental report. To the VTM per the supplemental report.
VTN.
Yeah.
Yeah,
Yes.
and then add the environmental monitoring following the Merritt Avenue model.
Correct.
I screenshot here.
And you have the deletions on there as well. That's good. There was something about lead and arsenic. We just
okay.
leave that part off. It just confuses things.
So nothing on the bioretention, right?
Well, the truck access, is that right?
That's the article. That's condition 85 that was mentioned early.
So it's already in there?
No, you're correct to remove it.
Remove, oh,
Yeah, remove condition 85, I should say.
Through the mayor.
yeah.
Yes.
Would you be willing to add the proposed conditions that the applicant has put forward for the two-story option?
All right.
It isn't perfect. I mean, they basically they kind of stretched out their units. So while it is two-story, there's a little bit wider. I can pull up the plan if you want to see that.
It cuts into Evelage Court, the driveway.
Yeah.
Yeah,
And
I'll-
and it's a
I'll-
little bit closer to
Sure,
Linda Vista.
sure.
Just,
I'll acknowledge that. I'll just say that I think that the neighbors would appreciate this version more than what is otherwise on the table.
Okay.
And to the extent that we can accommodate it, I think it would be good to do.
I can support that.
So with the condition proposed by the applicant, any modification
The two-story option for the 5 units, correct.
subject to the city attorney review? Because the city attorney haven't reviewed yet their condition for the two-story option.
I'm sorry, I don't understand the question.
Well, JR cut a deal, but they said they can't do the deal unless there's approval and review. That's where you're at.
I think they want certainty if there is any challenge to the project.
Yeah, they wanted we cut
The
them.
two-story option will be off.
I see.
So that verbiage, I think the city attorney hasn't reviewed that.
Correct.
So I thought the motion is with condition proposed by the applicant, subject to the city attorney review.
And if
just
the-
in case you find anything,
And let's say if the city attorney did find something, then that would go away?
then maybe let the mayor authorize the mayor.
Should it be city attorney and fire district?
Like that?
Competing
That
for
looks
screen
fine.
share right now.
That-
So I do have the, oh, there we go.
Video, can we share the overhead for the mayor?
That's true.
We can't say anything there. Might be better off up there.
Video, should we move to the other document? Thank you, Mayor.
Okay. So these are the 4 units on the south side, and you can see they are closer here to, actually in this area. And they're a little bit closer to the street than the previous, the alignment. Does that clear. And I think we all have a copy of this up on the dais, but it'll help the people in the audience here to see it. And you can see up here as well. It's a little bit closer. Am I missing any other parts to that change? Do I got it? Okay. All right. Okay. So your motion's complete?
Anyone
Can we
else has
can we look at it once more?
So it's recommended action with 6 items.
Can we see it on the screen, Vice Mayor?
Can you see?
Yeah, okay, there it is.
Can you zoom it a little bigger? Do you have a second?
Just to clarify, we're saying approve the project with these conditions?
Approve the exemption from CEQA and then these conditions.
Yeah, approve the recommended action.
Okay. Moore, second.
Just call a question.
I could call the question, however, there could be a challenge to calling the question, and then you'd need a super majority.
I think people are too tired for that.
Any other
You know,
amendments?
I have a, I'm not clear. What is it we're saying? We're saying let's not exempt from CEQA under these conditions? Or
Let's do
Well,
exempt.
it's exempt from
Find the
CEQA.
project, okay.
It's the recommended
All right,
action.
okay.
The recommended action exempt from CEQA. But I think we need to modify
Okay.
the tentative
Okay,
map
I got it, thank you.
and with some of these modifications, yeah.
Very good. Are we ready to vote?
Yeah.
Okay.
Through the mayor,
Yes.
sorry, right here. I just wanted to clarify for the additional condition for the environmental remediation, are we referring the project over to DEH regardless of whether or not an REC is found on site? Or are we only referring it according to what its standard practice is when something is found on site? Again, the language seems to indicate that we're just sending it to them.
Oh, it should be the standard practice.
Okay, perfect.
If we want to add a sentence at the start that says something about following Chapter 17
Right,
from
yeah.
the CMC, which is the point of it, that's all.
Perfect. Okay, I'll go ahead and do that.
Okay, thank you. And I accept the amendment. Okay, so Madam City Clerk, will you please reset our vote panel and we'll vote. Thank you.
The motion carries with Wong voting no.
All right, thank you. And thank you, staff, for your assistance, and for Pam Lee, thank you. And to our city attorney. So with that, we move on to our final item of the morning, item 4. Which is regarding the reconsideration petitions for Mary Avenue. And okay, so this is to conduct a public hearing to hear petitions for reconsideration filed on behalf of the Garden Gate Coalition for Mary Avenue Safety. including petitions for reconsideration dated February 27th, and also decisions on, I believe it's March 13th. Is that correct? All right. So, Madam City Manager, do we have a staff report? And is the person who requested the reconsideration here to?
Yes.
They are.
Zoom.
Okay. Oh, they're on Zoom. Wonderful. Okay. Very good. Please.
Thank you, Mayor. So this item is a hearing on 2 petitions for reconsideration filed by the Garden Gate Coalition for the Mary Avenue project, seeking council's reconsideration of its actions taken on February 3rd and March 3rd of this year. So these 2 petitions filed by the same party are pertaining to the same project and will be heard as one item. To present this item, we have Michelle Hernandez, who is an associate attorney with Elshire and Winder. And she will be presenting on behalf of the city. And before Michelle begins her presentation, we will first hear from the petition's legal counsel. I believe that they are on Zoom currently. So welcome and thank you for your patience tonight. You will have up to 16 minutes to present. After you are done, Michelle will come up and present the item.
Okay, Joshua, are you there?
Good morning, Mayor and Council. Can you hear me?
We can hear you. Good morning.
Hi. I'm Joshua Safran for the Garden Gate Coalition for Mary Avenue Safety. I will be relatively brief given the hour. We did send a letter a couple of days ago, which went into detail what I'm going to say, but for purposes of the record and for in case you didn't read that letter, I'll just sort of express our concerns here. So the basic issue for us is that this hearing, particularly given the late hour, is unnecessary and improper. The city should not be proceeding tonight as though this is an ordinary reconsideration matter under your municipal code section 2.08.096. And it certainly should not be used tonight to harden or ratify these approvals that are already under judicial review in Superior Court. There's several reasons for that. First, your own city attorney has already opined in writing that no reconsideration petition was required for the February 3rd actions. And so because there's a lawsuit that's now moot, the city attorney's reasoning was that there were no adjudicatory decisions that were taken at that meeting. And second, the March 3rd actions are not properly treated as adjudicatory reconsideration matters either. Those resolutions involve the street vacation and the exempt surplus declaration concerning city-owned land. Those are both indisputably public land and land use governance decisions, not ordinary quasi-judicial adjudications that would fall under the city's code governing petitions for reconsideration. Third, the coalition has already filed suit in Superior Court. The petitions were filed prior to seeking judicial review out of an abundance of caution because the city's posture here put us in a strange catch-22 where the city posted notices of exemption under CEQA, which started a 35-day coalition has already laid out that issue in detail. The point tonight is simple: reassembling the same body on an accelerated schedule with denial resolutions already teed up does not cure the fair hearing problem. It deepens the appearance that this result, which you're about to render, is predetermined. So the coalition's request remains the same. The city should acknowledge that these petitions were protective and not jurisdictionally required. It should decline to proceed as though tonight is a proper section 2.08.096 of the municipal code hearing. It should vacate the 4 subject resolutions together with the related CEQA exemption determinations and the notices of exemption. It should refrain from further implementation and reset the process only after full compliance with CEQA, Government Code Section 65402, the Streets and Highways Code, the Surplus Land Act, and the requirements of a fair and impartial hearing. I thank you tonight or this morning for your attention to this matter and for allowing me the opportunity to speak.
Thank you. And Madam City Manager, do we have a staff report?
I believe we have a short presentation that Michelle's going to lead, so I will turn it over to her now.
Okay, thank you.
Sorry, Lauren, are you putting up the slides or is...
Video, would you be able to share that? Are you plugged in or I need to share?
I'm not plugged in.
Okay.
There they are.
There we go. Just let me know when I can advance the slides for you.
Great, thank you. Good morning, Honorable Mayor, Vice Mayor, Council members. I will be walking through the claims made in the petitions for reconsideration along with the responses provided. Next slide, please. Two resolutions are up for consideration today. First, denying a petition for reconsideration and affirming actions taken by the City Council on February 3rd, 2026. And second, denying a petition for reconsideration and affirming actions taken by the City Council on March 3rd, 2026. Next slide. The February 3rd, 2026 resolution addresses reconsideration of the following council actions. First, approval of an architectural and site approval permit application number ASA 2025-006. Approval of a preliminary CEQA Exemption Determination, and approval of a Disposition and Development Agreement. Next slide, please. Under Cupertino Municipal Code 2.08.096, reconsideration is limited to the following. First, an offer of new relevant evidence which in the exercise of reasonable diligence could not have been produced at any earlier city hearing. Second, an offer of relevant evidence which was improperly excluded at any prior city hearing. Third, proof of facts which demonstrate that the City Council proceeded without or in excess of its jurisdiction. Fourth, proof of facts which demonstrate that the City Council failed to provide a fair hearing. Fifth, proof of facts which demonstrate that the City Council abused its discretion by not proceeding in a manner required by law and or rendering a decision which was not supported by findings of fact and or rendering a decision in which the findings of fact were not supported by the evidence. This hearing for reconsideration is restricted to evaluation on the grounds enumerated in the municipal code and is not a rehearing on the merits. Next slide, please. The municipal code also differentiates between adjudicatory and legislative actions. The approval of the ASA permit and the preliminary CEQA exemption determination have been determined to be adjudicatory actions subject to reconsideration. The approval of the Disposition and Development Agreement is considered a legislative action that is not subject to reconsideration. However, despite the determination that approval of the DDA fails because it is not subject to reconsideration, we have considered the merits of the petitioner's claims against the approval of the DDA as well. Next slide, please. With respect to the actions that were taken on February 3rd, 2026, Ground 1, new relevant evidence, the claim that was made by the petitioner includes external commentary by Krupka Consulting is presented as new evidence. Documentation submitted on February 10th, 2026 is presented, and the City's Planning Commission agenda as published on February 10, 2026 is presented. In response, the City has stated that the minutes and transcript of the February 3rd hearing reflect that Paul Krupka was present and discussed his findings during public comment. That made the findings in the Krupka Consulting report to become a part of the record that was considered by council at that time. Documentation on February 10th, not related to actions before City Council on February 3rd, 2026, and items listed on the Planning Commission agenda were not before City Council on February 3rd, 2026. Next slide, please. Prior to public comment, the mayor established the time, Ground 2, evidence improperly excluded. The claim made in the petition included impaired ability to present exhibits, insufficient public access to the complete plan set, and failure to provide the final amended versions of key approval documents. In response, prior to public comment, the mayor established the time allotted per speaker as permitted under the government code, and public comment proceeded accordingly, allowing each speaker their full allotted time. With respect to the plan set and supporting technical materials, they were made available at various stages of the project, including June 15, 2025 in the staff report that was filed, and the February 3, 2026 staff report. The published agenda accurately captures the item before council. Subsequent refinements did not change the overall nature of the item. The refinements were also reflected in the record through the staff presentation, council discussion, and the reading of the resolution titles, and were therefore available for council to consider. Next slide, please. In addition, the total time expended on public comment at the February 3rd, 2026 meeting was 59 minutes and 47 seconds, including 27 speakers that were allowed to speak regarding the Mary Avenue development. In addition, there was a study session that occurred on December 2nd, 2025, wherein public comment was allotted 1 hour, 9 minutes, and 30 seconds on available to 26 speakers. Next slide, please. Ground 3, proceeding without or in excess of its jurisdiction. The petitioner's claim includes sequencing and jurisdictional defects, approval predicated on future right-of-way vacation and public property disposition, and public land disposition via the DDA that they're claiming was not compliant. In response, the city states that an analysis related to the sequencing of events was discussed before council at the study session on December 2nd, 2025. And additional information was provided in the supplemental report for the meeting on February 3rd, 2026. The DDA conditions its implementation on subsequent approvals, and the petitioner does not provide legal authority indicating that those items must be completed prior to entering into the DDA, rather than structured as conditions. Next slide, please. Ground 4, failure to provide a fair hearing. The claims include amendments adopted without public review, inconsistent basis for CEQA presented to the public and decision makers, post hoc process to retrofit findings, conflict of interest bias, due process violations, and attacks on council's ethics and credibility. In response, the city offers that the published agenda accurately captured the item before council. Subsequent refinements did not change the overall nature of the item. The refinements were also reflected in the record through the staff presentation, council discussion, and the reading of the resolution titles, and were therefore available for council to consider. As reflected in the record, the city identified the applicable CEQA treatment for each relevant approval. Ultimately, it made its CEQA determination for the project in connection with the later discretionary actions considered by City Council on March 3rd. Statements made by council during the deliberation reflect their evaluation of the arguments presented in the record. The petitioner does not identify legal standards nor facts in the record that would support such claims for bias, or a disqualifying conflict of interest. Next slide, please. Ground 5, abuse of discretion. The claim includes invalid reliance on CEQA exemption and improper segmentation, required findings not made for vacation, constraints on public subsidies and gift of public fund issues, findings inadequate regarding public health, safety, or welfare. In response, the city offers that as reflected in the record, the city identified the applicable CEQA treatment for each relevant approval and ultimately made its CEQA determination for the project in connection with the later discretionary actions considered by the City Council on March 3rd. The vacation of the right-of-way and the declaration of exempt surplus land under the Surplus Land Act were not before council at the February 3rd meeting. The petitioner has not cited legal authority in the record suggesting that the matters before council on February 3rd would constitute an improper use of public funds. The project's funding has been discussed in the record at length since at least April of 2025. The petitioner also references a report by Krupka Consulting and staff analysis related to an adjacent city project. Materials concerning those items were publicly available at the time of the February 3rd meeting, including through public comment, and therefore could have been considered by the council. Next slide, please. In conclusion, with respect to the February 3rd, 2026 resolution, Petition 1 failed to satisfy any of the grounds for reconsideration pursuant to Cupertino Municipal Code Section 2.08.096. There was insufficient evidence to show new or improperly excluded evidence, procedural errors, or improper actions. Although we have included substantive review of the petition in connection with the DDA, we have also determined that approval of the DDA is not an adjudicatory action subject to reconsideration, and any request for reconsideration is also denied on that basis. Next slide, please. The background with respect to the March 3rd, 2026 resolution includes addressing reconsideration of council actions, including resolution number 26-024 vacating the public right-of-way along Mary Avenue, CEQA Exemption Determination, and approval of the resolution number 26-025 declaring the project site exempt surplus land pursuant to the Surplus Land Act. Next slide, please. Excuse me. Ground 1, new relevant evidence. No claims were raised by the petitioner. Next slide, please. Ground 2, evidence improperly excluded. The claims include procedures materially constrained, presenting documentary and visual evidence. In response, the city offers that prior to public comment, the mayor established the time allotted per speaker as permitted under the government code, and public comment proceeded accordingly, allowing each speaker their allotted time. Next slide, please. The time expended on public comment at the March 3rd, 2026 meeting included 18 minutes and 28 seconds for 16 speakers regarding the resolution on vacating the public right-of-way. There was also a total time of 12 minutes and 51 seconds, allowing 11 speakers with respect to the exempt surplus land declaration. Next slide, please. Ground 3, proceeding without or in excess of its jurisdiction. Claims include the March 3rd actions cannot cure or retroactively validate jurisdictional defects because city unlawfully committed itself through February 3rd approvals. Sequence of Surplus Land Act declaration. In response, the city offers analysis related to the sequencing of events was discussed before council at the study session on December 2nd, 2025, and additional information was provided in the supplemental report for the meeting on February 3rd. As mentioned previously, the petitioner does not provide legal authority indicating that the sequencing of approvals was improper. Next slide, please. Ground 4, failure to provide a fair hearing. The claims include no recusal of council member with a disqualifying conflict of interest, restrictions impaired presenting responsive evidence. In response, statements made by council during deliberation reflect their evaluation of the arguments in the record. The petitioner does not identify legal standards nor facts in the record that would support such claims for bias or a disqualifying conflict of interest. Prior to public comment, the mayor also established the time allotted per speaker as permitted under the government code, and public comment proceeded accordingly. Next slide, please. Ground 5, abuse of discretion. Claims include invalid reliance on CEQA exemption and improper segmentation, failure to follow Streets and Highways Code Section 8324B, Surplus Land Act and public disposition requirements, Resolution number 26-025 regarding the SLA, improperly bootstraps what they consider not necessary for the city's use determination. No evidence provided to support that the vacated area is not needed for present or prospective public use, and CEQA finding contradicted by the CRIPCA consulting report. In response, the city offers that as reflected in the record, the city identified the applicable CEQA treatment for each relevant approval and ultimately made its CEQA determination for the project in connection with the discretionary actions considered on March 3rd. Analysis relating to the sequencing was previously provided and discussed before council in the December 2, 2025 study session, and additional information was provided in the supplemental report for February 3rd. As mentioned previously, the petitioner does not provide legal authority indicating that the sequencing of approvals was improper. The record includes the March 3rd staff report, staff presentations, and council meeting minutes, which contain evidence supporting the council's findings on the vacation and SLA declaration, that the vacated area is not needed for present or prospective public use, and that the site is surplus land under the Surplus Land Act. Next slide, please. The March 3rd, 2026 resolution in conclusion, Petition 2 fails to satisfy any of the grounds for reconsideration pursuant to the municipal code. There was insufficient evidence to show new or improperly executed evidence, procedural errors, or improper actions. Although we have included substantive review of the petition in connection with the approval of the vacation, we have also determined that approval of the vacation is not an adjudicatory action subject to reconsideration, and any request for reconsideration can also be denied on that basis. Next slide, please. The recommended action before you today is first to find that the petition for reconsideration dated February 27, 2026, pertaining to actions taken at the February 3rd, 2026 City Council meeting, failed to satisfy any of the grounds for reconsideration pursuant to Cupertino Municipal Code Section 2.08.096. And second, to find that petition for reconsideration dated March 13, 2026, pertaining to actions taken at the March 3rd, 2026 City Council meeting, failed to satisfy any of the grounds for reconsideration required pursuant to the Cupertino Municipal Code Section 2.08.096. And third, adopt draft resolution number 26-032. And fourth, adopt draft resolution number 26-033. Thank you.
Thank you. Catch your breath. So the hearing's open. Do we have any clarifying questions from the council at this time? And I see a hand raised from Vice Mayor.
Oh, no, that's
from before.
From before.
All right. No one has any questions at this time. We can go for public comment.
Yeah.
Madam City Clerk. 2 minutes. 2 minutes.
Two is good.
Two. Okay. 2.
2 minutes? Okay, we have 6 requests to speak in person, and at this time I see 1 request raised virtually. Oops. So we will welcome Eli Robles, followed by Jennifer Griffin, which I don't see, followed by Connie Cunningham, followed by Kenneth Javier Rosales. So welcome, Eli. You have 2 minutes.
Good morning, Mayor Moore, council members, and staff. Thank you for giving me an opportunity to speak tonight. My name is Eli Robles. I'm a field representative for Carpenter's Local 405 here in Santa Clara County. The Mary Ave Villa project represents a significant opportunity for the city of Cupertino, in addition to delivering much-needed affordable housing that will allow residents to live, work, and fully participate in this community. The project also has the potential to generate high-quality, family-sustaining jobs for local carpenters. These are the kind of jobs that provide stability, offer livable wages, health care, and a pathway to long-term careers and retirement. When a project incorporates local hire and strong apprenticeship opportunities, it not only strengthens the local workforce, but also reflects the values of a city committed to equity, opportunity, and community investment. By utilizing apprentices from state-certified programs, the city can be confident that the work will be performed by individuals who are well-trained, professional, and dedicated to completing the project safely and at the highest standards. We are actively working with the developer to help ensure the project meets these goals, and we look forward to reporting back to you in the near future as that collaboration continues to move in a positive direction. Thank you for your time.
Would the city attorney provide some clarification on what the types of comments that may be made so that they're within the agenda item that we have noticed?
Yes, thank you, Mayor. We really should keep our comments to the question of reconsideration and whether there is any evidence that, whether any of the 5 grounds were not complied with.
Okay, so speak to the reconsideration and the grounds. Okay, thank you.
Okay, I don't see Jennifer Griffin, so we will welcome Connie Cunningham, followed by Kenneth Javier Rosales, followed by San Rao, followed by Jean Bedord. Welcome, Connie.
Thank you, and good morning to all of you. Honorable Mayor Kitty Moore, Vice Mayor, Council Members, City Manager, and City Attorney. My name is Connie Cunningham, Housing Commissioner, speaking for myself only. I strongly support the recommended denial of petition for reconsideration. I urge the Council to approve the recommended action as stated in the agenda. Thank you for this time to speak.
Thank you, Connie. Next, we will welcome Kenneth Javier Rosales.
Good morning, Mayor and Council. My name again is Kenneth Javier Rosales. I'm the Leadership Development Program Manager with SV at Home. Again, we're a housing justice organization, member organization that works across Santa Clara County to advance affordable housing. We're here in strong support of the Mary Avenue Villas project and urge adoption of staff's recommendation on the reconsideration petitions. Sorry, let me try to adjust this. There you go. We are absolutely ecstatic about this 100% affordable housing development that carries deep levels of affordability. It will house Cupertino residents who already live, work, and rely on services in the community.
Please focus your comments on the reconsideration, not the merits of the actual project.
Oh, sorry.
Thank you.
This project has gone through extensive review and multiple council approvals, and staff has determined the reconsideration petitions do not meet the required legal standards. We hope you can uphold the staff's recommendations. It maintains consistency and integrity in city decision making, provides certainty for time-sensitive housing financing, and supports the city's housing element commitments. Reopening decisions at this stage risks project viability, undermines confidence in the process, and delays much-needed affordable housing. We respectfully urge the City Council to deny the reconsideration petitions and adopt staff's recommended findings and resolutions. This ensures the project can move forward and deliver housing for those who need it most. Thank you.
Thank you, Kenneth. Next, we will welcome San Rao, followed by Jean Bedord.
Good evening, Mayor Moore, Vice Mayor Chow, council members. I'm a planning commissioner speaking on behalf of myself only as a resident. I urge the council to reconsider based on a number of procedural errors that have compounded over time across different councils, different city managers, different city attorneys, and a process that is not the fault of any one party, but a compounding set of failures that I'm going to outline. In the first failure, the city ran an RFP on public right-of-way before the vacation was complete. The RFP was never part of the administrative written record. It is unclear to this day if the RFP was for a ground lease or for a sale. It is unclear if the city got a single respondent, why the city could not rerun the RFP as is always done with other projects, including other agencies. The city then went on to form a parcel before vacation. Parcel formation presupposes disposition-ready property. Doing that indicated bias because vacation should be unbiased and should be based on findings from the community. The city pursued vacation before the general plan conformance. In fact, the council held a meeting ahead of the planning commission meeting, and the resolution that the council signed specifically said the project is in conformance with the general plan when that had not yet been established. The general plan conformance itself was biased. I was the only commissioner asking questions for almost an hour and a half. A member of the public said for over 25 years there's been no vacations other than Prunridge Avenue. And yet, out of the 5 commissioners and the chair running the meeting, I was the only commissioner asking questions. And eventually, the commission called the vote. And the only reason we were able to save that is it needed a supermajority. The city moved to a single-party negotiation before notifying HCD's interest list. There is no way the city could have assumed that this project was a Rotary project, that it could be negotiating with charities, or that this was IDD project. Thank you.
Thank you, Stan. Next, we welcome Jean Bedord.
Good morning. My name is Jean Bedord, and I'm a Cupertino resident. It's late, and I'm tired of all of these frivolous legal actions. They are simply delaying tactics aimed at blocking this badly needed housing for our community. I urge you to approve the recommended actions and deny the reconsiderations. Thank you for your consideration, and let's get this over and go home.
Thank you, Jean. Mayor, that concludes the request to speak in person. I do have one hand raised virtually, so we will welcome Ranjan.
Good morning, council members. I was asleep, and thanks to nature, it awoke me, and really appreciate all of you at this time of hour. You guys, when all of you are sitting there and doing this work, we are not against the affordable housing as such, but the location, as we talked earlier, is just not appropriate. I urge.
Pardon, we need to stick to the reconsideration item, not the merits
Yes.
of the project. Thank you.
Yes, thank you for reminding. I urge the council members to agree to what Joshua, our lawyer, for representing the Cupertino Garden Gate members here, is stating in his speech. As you said, we are not against, the members are not against that, and then this was not at all informed to other members here in the locality. And let me see, there are kind of, I urge all the council members to vote from your conscience and not an unbiased decision is needed here in response to all the objections raised by the citizens here. I'm speaking on my behalf today, but there are hundreds and hundreds of residents who talked earlier about this. We are not against this project at all, but the location is not appropriate at all. Thank you for allowing me to speak, and then hope you accept the reconsideration and deny going forward. Thank you.
Thank you. Mayor, that concludes the request to speak on this item.
Okay, thank you. For purposes of deliberation, well, are there any further clarifying questions?
Are we able to ask the petitioner if he's still there, or is he off of the table?
The petitioner is still available virtually?
And did you have a question for the petitioner?
I did. I wanted to know what he thought was new material versus what was not. And I was hoping to ask him that question. Is that okay? Can we do that? Okay. Josh, if you're still there, I want to understand what you consider was new material, as the city responded back by saying there was no new material. And the whole point of a petition is to introduce new material. So can you clarify what the new material was?
Yeah, one of the grounds that has to do with new material. It's not the only ground. It was also if the council acted without. Yeah. So I'm a little confused by the city's response to that. What we pointed out was Mr. Krupka submitted a second expert report after the February 3rd meeting that spoke to new and different cumulative impacts than what had been evaluated before in his first report. And so the fact that he spoke at the February 3rd meeting is irrelevant. The details in an expert report issued after that February 3rd meeting were new information. It was certainly new to us, and we provided it to the city as part of the petition.
Okay, thank you. Appreciate that.
Are there any further clarifying questions? Councilmember Fruin.
So it's not just a matter of whether the evidence was produced after the fact, it is also whether that evidence could have been produced in time for the hearing. Is that not correct, Madam City Attorney?
That's correct.
Okay, so presumably it could have been produced by the time of the hearing. In fact, it was denominated a quote-unquote typo, which I did not find in any way believable.
Yes.
Okay, thank you.
Okay, I'm not seeing any further clarifying questions. The public hearing is closed. Do we have a motion for deliberation purposes?
Sure, I'll move the staff recommended action.
And Councilmember Mohan?
Second.
Second. So we have a motion and a second. Do you have any hands raised to speak from the council? Councilmember Wong?
I'm just going to reiterate, I may be the only member that's going to say this right now, but I'm going to say the process was backwards. The order of operations was not accurate, and I can understand why there was a petition for this. I'm trying to avoid a lawsuit between this community and us, and I don't know exactly what the approach will be going forward, but it seems like a valid request on my end. I'm not a legal expert. I know we've got legal experts here. And this is what we're all going to continue. How the law is interpreted is always very different than what the community wants, and this seems to be an ongoing issue. So I'll leave it at that.
Councilmember Fruin?
Yes, I'll just say that the community can avoid a lawsuit because Mr. Safran and his clients can withdraw their suit.
Vice Mayor?
Yeah, I think I stated my concern about the project regarding there is no sufficient ground to vacate the land because there is still need for parking for the city. However, for the reconsideration regarding like the argument that the order of operation is out of order, we shouldn't have done to the RFP and all that. These are all arguments that have been brought before when we had the consideration. So these are not new arguments. So, and then the new evidence provided, it doesn't seem to really provide new argument, although at the time when the traffic study was sent to me, I did forward it to the staff and ask if the staff can address those questions that was raised in the study, but I never got an answer. So it's not new information. However, I would say we did not address those concerns raised in the study at the time. But is that ground for reconsideration? It's new, it's old evidence, but we didn't get around to answer those questions, the concerns raised. Yeah.
That's correct. So that's not really a grounds for granting the petitions and moving into an actual reconsideration on the merits.
Mm-hmm.
But I hear what you're saying.
Yeah.
Councilmember Wong?
Oh, I'm back in queue. I'll take it off. Let me get out of queue.
I'm not seeing any further hands raised. We have a motion and a second. Madam City Clerk, will you please?
There are two parts to this thing. All four? We're doing it all at once, right?
It's all at once.
Okay. Staff rec.
Okay. Okay, so Madam City Clerk, you've reset the vote panel. Please.
So I'm sorry, let me make sure. Was the motion the recommended action, which is both resolutions? Okay, very well. Thank you.
Thank you.
The motion carries with Wong voting no.
Okay. That was our last item of the evening. I want to make sure I'm not missing anything from the agenda.
I wish everyone a happy Passover.
That's true.
We miss.
Yes. So we wish everyone happy Passover. And with that, this meeting is adjourned. We will be back next Tuesday.